Sorry, we are late. Yes.
One matter for tomorrow, Your Lordships. Education matter, tomorrow, Your Lordships. The seat matrix is going to close day after tomorrow. If my name is not included tomorrow, I'll not be permitted to take admissions to MD course, Your Lordships. There's already a direction in this honorable court, so I'm filing a fresh writ petition to consider, Your Lordships.
Tomorrow.
Tomorrow.
Non-compliance of office subjects. I filed an application minutes for recall of that order minutes. Minutes may have this week or next week minutes subject to convenience of the
21st. 21st.
Item, I make mention. Item 63, my lord. There is some urgency, my lord. Couple of times didn't reach.
Serial number?
63, my lord. There are 700 workers who are sitting idle. End of the day, if your lordship can kindly consider taking up this, my lord, only for mandamus. But there's some urgency. 3 times it didn't reach. So,
Let us see, at 11 you can't say that
No,
it
no.
will not reach.
I'll wait for the entire day before rising up the court if your lordship can consider this.
Yes.
Right.
Yes, anything, yes.
Serial number 8, my lord. Kindly I request to have next week, my lord.
Serial number 8.
Serial 8, my lord. It's a playground, my lord, reserved for,
Oh, you on time?
please, next week kindly.
Why?
They are not ready, my senior.
Not ready.
Please.
We are ready.
Please.
22nd August,
Much obliged.
Lords, one submission. Serial number 58, my lords.
58.
The matter has become infectious, my lords. I am filing a memo for withdrawal.
You are
58, my
Mr.
lords.
Sunil Shastri.
Yes.
Learned Advocate Dr. M. Sunil Shastri invites attention of the court to the memo dated so and so file stating that the contempt petition become infectious in view of the statement and the memo dismissed as infectious.
Please.
Serial number 19, my lords.
19.
Yes, my lords. Parties are intended to compromise the matter. Kindly have a one month time. My lords. Serial number 19, my lords. Accused and complainant both present to court.
Settling.
Yes, my lords. Kindly have it on 1 month time, my lords.
Should we record that they are settling?
Till not settled, my lord. They are intended to
Should
settle.
we record that they are in the process of settlement?
Record it.
Learned Advocate for the complainant stated that the parties are engaged in the process of negotiation to settle the dispute outside the court. In that view, he seeks time for 4 weeks and go to and 5th of September.
Much of this.
My lords, kindly. Serial number 13, please, my lords. I appeal to the respondent, please, my lords. For short accommodation, please, my lord. There's some inconvenience to the please. I've informed the appellant as well.
I appear for the appellants, my lord. We don't have any
Serial number
objection.
1-3, please.
Did time.
Please, my lord.
And it will go to 10th September
Please.
Obliged.
Grateful, my lord.
at the request of learned advocate for the appellant.
Respondent.
10th September.
Respondent, my lord.
Respondent,
Please.
10 to 10 September. Yes.
Grateful.
Lords, I was appearing for the appellant in this matter.
Yes.
My lords, in writ petition number 1488, it's a PIL matter. It is a government land actually. So the respondents are trying to encroach the land and they're developing a residential layout. So I've filed an interim application. Kindly hear that on Wednesday, my lords. It's a PIL, it's a government school matter. So I am a senior citizen and I've filed a PIL in this to make sure that the land.
What is the date given in the main petition?
My lord, it is actually not posted because previously I received an NOC and cleared the office objections and I'm posting it now. And the land's development works are going on. That is the reason why.
So let it be posted, main petition. On 3rd of September.
My lord, it is a fresh case, my lord. It is a for civil contempt petition.
Pardon?
Civil contempt petition, my lord. It has the accused have not complied with the final order of this honorable court, my lord. It was of 25th January of 2020, my lords. It was to mutate the name of the petitioner.
What do you want?
My lord, memo for posting, my lord.
Posting. 28th of August.
My lord, this week, my lord. This week, my lord.
Why?
The order is of 2023, my lord. They have still not complied with the order of the Honorable High Court.
21st August.
Much obliged, my lord.
Lord, I for restore the matter. I for restore the matter, dismiss for non-compliance.
Restoration. It will be restored. Let it be listed, no memo for that. It'll get to be listed within week, don't worry.
List two, seal number one. Mr. Vinay Kuttappa.
So it is over now?
Please, my lords, they permitted me to modify the, this petition has become infectious.
Learned advocate, Ms. So-and-so, so the petition stated that the respondents have already permitted the petitioner to change the category,
Category.
to
my lord.
mention the correct category for the purpose of admission to
Uh,
MBBS course.
Please, my lord.
In that view, the
Not
petition,
MBBS, my lords.
petition no more survives for further consideration, disposed of accordingly.
Seal number two. VB Sidramaya.
Appearing for petition, my lords, this matter is with respect to admissions to MBBS course under UG NEET. That annexure A, page number 13. That it will start from, it has started from the academic year 2023-24. Well, the petitioner has filed an application under the two reserved category. One is category 2A and another is scouts and guides category. At page number 13, my lord, annexure A. My lord, subsequently, as per annexure B, page number 17, yes, category 2A has been accepted. And thereafter, my lord, he has undergone for document verification as per annexure C, page number 18, for scouts and guides category also. My lord, annexure E, page number 20 is the governor's award for attending the camps under the scouts and guides conducted by the respondent 5 and 6. But thereafter, he has filed an application. His application has
Want
been.
us to rewrite the rule, how can it be?
Please, my lord.
What is that rule? We are complaining.
My
of
lord,
9C.
rule is, the reason, my lord, all the applications of all the students has been rejected from past 5 years.
Page 26, my lord.
Yes.
Declare that portion of 9C. How the first pair can be granted?
My lord, my lord, for the past 5 years, because of the COVID situations, Rashtrapati awards were not issued. All the 5 seats becomes vacant. That has not been filled.
Can't write a rule for you.
My lord, the rule I have challenged.
So whatever.
But under the
whatever is-
peculiar circumstances, my lord, the rules cannot be implemented.
Lord, no, the central government has not issued that award. They are seeking for the state government to modify the whole.
So because,
Rule. It can, no relief can be granted. Difficult to grant any relief.
we dismissed,
rule
it may
returnable
be
on-
decided on merits, my lord.
Rule returnable on 10th, 11th September. Nothing more.
So list one, the contempt matter, seal number one.
I'm appearing with the complaint in this case for 2 weeks time may be
Sorry,
given
fine.
for to comply the office objection.
My lord, in view,
One
of-
second.
in
one
view of,
second.
in view of IN number 2, I will not
Yes.
press the memo for consideration of interim prior. There is an office objection with respect to memo that may be dismissed as not pressed, my lord. I have filed, subsequently I have filed IA.
Not pressing I.
I will press IA,
My
my
lord,
lord, I will
I-
not press
I
I am
memo.
appealing,
Memo, I will not press.
Interim relief is refused. It can't be granted. Even main prayer cannot be granted. Difficult to grant. Only for your benefit, you are issuing rule so that they can file report.
The notice has been issued, my lord, they have already filed.
More than notice is issued, rule returnable.
Yes, sir. Yes, seal number one. Mr. Patta BC.
Nobody.
Seal number two. Manish Kangovi.
Appearing for the petitioner, my lords. Order of the learned single judge, my lords.
Notice it.
Complainant.
Notice returnable 11th September.
Very much.
Still number 3. No, sir.
Is regarding
Where is the order under contempt? At which page?
order is at,
Which page? Order is at which page?
order is at page 62, writ petition order.
62.
This writ petition was challenged by the respondent, filed by the respondents, challenging the positive order of the authority concerned to allot the site. Register the site. Then para 12 onwards, my lord, para 11.
Now your writ petition is dismissed.
Writ petition, there is dismissed, confirming the order of grant.
Confirming the order of,
Well, para 11 onwards, the authority is directed.
where is that order? That is what we are asking, which you want to comply with. Where is the order which you want to comply with?
My lord, my lord, kindly annexure K at page 50 kindly be looked into. At internal page 51. Last sentence, last para.
Endorsement issued by the joint registrar of
Under the circumstances you are directed.
page. Which page?
Their writ petition is confirming the order of grant. That's what I'm saying.
You only want to know which order you want to comply with.
Order is when
Is nor is, where is that in the files of the contempt petition?
I think I have not made the wisely very clear. Now what I say, my lord, is-
Unless we see the order, we are not going to entertain. There must be an order direction on the record which you want to comply with.
my
Where
lord,
is that?
may say,
What you are showing is the dismissal of the petition. And saying that some order thereby is to be complied. Which is that order?
that order is, my lord, kindly page 62 onwards for a moment kindly be looked into.
60?
62 onwards, order in the writ petition. Then para 11 onwards, I
That
just,
is, Mr.
I'm
Counsel,
permitted
that
to
is the
read.
order passed in the writ petition, dismissing the writ petition,
That I am saying,
by virtue of which some order is to be complied. Which is that order?
by virtue of this dismissal order,
Correct.
the grant in my favor is confirmed.
Where is that?
My,
What is confirmed? Where is that?
my lord, kindly, that's what I am saying. Kindly, page 51,
51.
translation. Translation is at page 51. Original order is at 49. Last sentence. Under the circumstances, you are directed to register the site bearing number 219 in the name of Shri Praveen Kumar BN and report the same to this office. This was challenged.
In fact, there is no positive direction in the order of law in a single judge to entitle you to invoke the contempt jurisdiction. Anyway, notice returnable on 12th of September.
This is number 4. Devarajan.
On behalf of.
On the last date of hearing, my lord, the council made a submission that they have filed vacating stay.
Pardon?
But on the last date of hearing, that is on 24/6/2024, my learned friend made a submission that they have filed the vacating stay application. But
Yeah.
it was vacating stay application in the writ petition. Based on interim order, we have approached this honorable court. But after 2 days, my lords, after taking time, my lord, they have filed the application for vacating stay. My lord, this is a termination order, my lords. Order was passed on 3rd April 2024. My lords, termination order was passed on 3rd April 2024, my lords. Stay was,
Where is the order? That is
my lords, annexure Q, page 208, my lords.
208.
Page 209, my lords.
Then what happened?
My lords, thereafter, my lords, I made a representation, my lords, on 17/4/2024, my lord, on 17/4/2024, my lords, I made a representation to continue my services, my lords. They did not continue my services, my lords. Thereafter, my lords, contempt was filed, my lords, on 31st May 2024.
Go before the same learned single.
I appear to the accused, my lords. The order has been complied, my lords. I may be permitted to pass on the.
Complied with.
Please, my lords.
Is
the
reinstated.
Complainant has been reinstated, my
Then what?
lords.
No, my lords.
I shall be permitted to pass on minutes and the notice has been even given to the complainant as well.
My lords, if it is passed. Lords, they say, my lords, 29/4/2024, they have complied the order, my lords. But till today, why should I file contempt petition then, my lords?
So it is complied with,
No, according to this order, my lords, they have complied. my lords.
what's more, learned counsel.
Let them implement the order, my lords.
Learned counsel for the respondent, so and so, produce order of reinstatement of the complainant. Copy of which is given to learned advocate for the complainant. Post of the order shows that the directions of learned single judge passed in the interim order, which is brought under the contempt jurisdiction, is complied with as the complainant reinstated. Post of the factual position could not be disputed by learned advocate for the petitioner. In the above view, nothing survives in the contempt petition. It is disposed of accordingly.
Number 5. To Bhargav D. Bhatt.
Lords, despite there being an interim order, my lords,
Yes,
the accused respondent, my lords, is continuing to construct. On the last occasion, my lords had directed the government advocate to ascertain the status on site and report them. We have produced photographs, my lords, with my petition at Annexure B and Annexure C to show the difference in how the progress of construction, my lords.
Mister, this is an interim order. Why should we? Interim order. You are appearing?
That's no, we have not made parties minutes, just because they mentioned it.
Because let's see, has appeared before the writ court also. They have filed for IA to vacate the interim order.
Notice written in. Nobody is appearing. So notice.
Please. My lords, I may be allowed to take notice on the lawyer appearing before the writ court, my lords. The accused is represented by an advocate before the writ court.
Only to accuse. We have to serve. Well.
December 6. Chandrakant Arik.
Appear for the
Notice returnable on 12.
Annexure B is the,
Notice written.
please, me.
December 7. The Shreyas S. Kumar.
This is with respect.
That's the report insofar as the first response. Madam. Okay, sir, again.
In fact, in
This is a coastal area?
Please, my lords. My lords, out total 11 people went missing, my lords. Out of 11, we are able to retrieve 8 bodies, my lords. 3 of them are still missing, my lords.
Still how many missing?
3, my lords. In fact, we have given day to day what has been done, my lords. As of now, my lords, temporarily, my lords, this rescue operation has been halted. Phone. No. No. That is on. My lords, as your lordship seen, my lords. You have the photographs, just to have an image.
Rescue operations were required to be stopped.
Now, as of now, we have stopped, my lords. In fact, past 16 days, my lords, which when we are deployed NDF, 31 personnel of NDF were there, my lords, 31. SDRF, 42 personnels. Fire and emergency service, 26 people were there, my lords. And Navy deep sea divers, nearly 12. Then Indian Army humanitarian aid and disaster relief team around 60 members, my lords. All these people were there trying to rescue, take all measures required, my lord. All men and machinery which was humanly possible, my lords, all steps have been taken. In fact,
Total, how many persons were missing after this landslide?
totally 11, my lord. Out of them, we are able to recover 8 bodies out of the 11 missing. 3 people are still missing, my lords. So we are, and out of the total red alert, my lord, as your lordship saw the note which I've given, out of the total number of days past 19 days, my lord, 4 days were red alert, my lord, where the rain was very extreme, my lord. Per day, the rainfall was 204 mm, my lord. And the rest of the days, most of the days were orange.
Who appears for the petitioner?
My lord, senior counsel has been.
My lords, I appear for the petitioner. I am led by Mr. V. Chidambaram, senior advocate. He is on his legs. But as of now, my lords, please, my lords.
Have you got the memo produced today?
I've just received
You
this.
got. So are you not satisfied with these efforts?
My lords, I am yet to see the memo which has been produced today.
Yes.
So as of now, Your Honor, have been told is the search has been stopped for last 4 or 5 days.
Mister, you
And
are
yesterday also there was an attempt by deep.
So have
Beg your pardon?
have you the benefit of today's memo or not?
Let's, I pray for 2 days time. Maybe
No, Your Honor, I don't have.
That is the handicap for you and for us both, that you are online. And it is. Anyway, are you not satisfied with this effort?
Whatever humanly possible.
Whatever is given by you.
Your Honor, as of now.
Will not have. But then you don't know anything. Till you know.
Your Honor, yesterday there was an attempt.
May make one submission, madam.
What you are doing?
Lord, we have deployed, my lord, NDRF, my lord, the Navy, sonar teams have been inducted, my lord. Now, my lord, humanitarian assistance and disaster relief, my lord, they have jumped into the sea.
River is there.
Yes, my
River
lord.
is at,
Lord,
under 2 kilometers, it joins the sea, my lord. It joins the sea, my
The
lord.
reason why the state has also stopped, halted the operation is this, my lord. Excess water current is there, my lord, above 7 knots. The operation can be undertaken only till 2 knots in the river, my lord. Excess to that, my lord, there is excessive water current. That is where the operation have been stalled. The reason is this, my lord. Insofar as the Union of India is concerned, my lord, sonar team which detects the bombers also.
So 15 days have passed.
Please, my lord, from 26, it has been continued. My further instruction is it not stopped in the sense stopped. They are doing it, my lord, halted in the sense when it is impossible to do it, it is halted, my lord. So they're still continuing what is humanly possible to be done. It is not that they have stopped, my lord. Because of the heavy, sorry.
You continue the efforts to.
We are Your Lordship, we'll continue the effort. That's the instruction. We'll definitely continue with the efforts. My lord. It's not halted as such because of the heavy rain. During that period, it has been done.
Yes, madam. They will try to find out the bodies. Rest of the efforts we are dissatisfied unless you are saying something else.
So what Your Lordship may instruct, like we'll give the report. There's no urgency. Either it may be closed or it may be called after 2 weeks or something like that, my lord, so that we can give further updated status what is happening. And it's not their case, my lord, we are doing, not doing anything, my lord. Even they know what we are doing with the efforts taken. In fact, the NDRF, State Disaster Force, Navy, everybody is taking.
Maybe taken up next Monday, my lords.
In course of the hearing today, Honored Advocate General Mr. Sashikaran Sethi placed on record the details of the efforts undertaken since the day of disaster, that is 16/7/24, when the landslide occurred at Shiruru village, Vasarakudi Digi village, Ankula Taluka, Uttarakhand district. It was submitted that notwithstanding the impediments created by heavy rains and floods, and that there were orange alert issued for 3 days and 5 days, 6 days, on several days, and yellow alerts on some days. Some of the efforts were intensely continued to rescue for rescue operations and to detect the missing bodies, missing persons. Learned Additional Record General Mr. Shanti Bhushan joined to submit that the central government has also, in coordination with the state government.
I've filed the report also.
Central government in coordination with state government has been assisting in the rescue operations by deploying the groups of National Disaster. What is that NDRF?
National Disaster Response Force.
What R means?
Response Force.
Response Force.
And State Disaster Response Force.
Have been working jointly with state disaster
response force.
It was submitted that the agencies of Indian Army, Indian Navy, and other rescue agencies are also employed in the rescue work. It was given out that total 11 persons were found missing since the date of landslide, and till date 8 bodies
Please.
8 dead bodies have been recovered. Paragraph. The court was assured that the efforts will be continued for rescue and rehabilitation and also to find out the missing persons. Full stop. Learned advocate Miss so and so for the petitioner prays for time to request the court to post the petition on next Monday. Accordingly, stand over to
Any day.
what is the next Monday?
12th.
12th.
Can I request, my lord, your lordship may add Indian Coast Guard also, my lord, because even they have helped a lot, my lord,
Indian Coast.
because they have assisted quite a bit. My lord. Great.
Eight urgents, number 9. Praveen HP.
Those objections have been complied with, my lords, last week. Objections have been complied, my lords, last week. So if it pleases, my lords, may I submit, my lords, on?
Want to submit, you are welcome.
Let's IPF respond number 3 and 4. Please, my lords, I have filed the writ petition, my lords, seeking my lords to direct the respondents, my lords, to implement, my lords, in Sadashivanagara, which is reserved, my lords, for residential purposes, not to carry out commercial activities, not to permit carrying out of commercial activities. My lords may kindly see, we have filed, my lords, one writ petition, my lords, in
Where is
2000.
that order?
My lords,
Where is that order? Oh, where is the order for earlier writ petition?
my lords, at annexure F, my lords, at page number 170. 170, my lords.
170.
Please. My lords, I have filed 2 writ petitions, my lord. I have produced 2 writ orders before my lords. Page number 170, my lords. My lords will find the earlier order, my lords. At page number 173 is the operative portion.
173.
Please.
That is some representation.
170, my lords. My apologies.
170.
Please. As a matter of abundant caution, we consider it just and appropriate to direct respondent BBMP to furnish the details of the action taken in furtherance of the undertaking given to this court to the petitioner. It shall be open for the petitioner to verify the correctness thereof, and in case it is necessary, to revive the instant writ petition by moving so and so. My lords, in this writ petition, my lords, the respondent had undertaken to initiate action, my lords, against all those people who are using the residential properties, my lords, for commercial activities. And they have filed a status report also, my lords, which is produced at page number 151. My lords, 3 categories of violators were identified by the Honorable Court, my lords. First category is, my lords, those who are using the residential properties for commercial activities and those who have stopped it. Second category, my lords, are those who are using the residential properties for commercial activities. But however, my lords, with the implementation of the Master Plan 2015, these areas, my lords, have been earmarked for commercial activities, so they were also allowed. Third category, my lords, irrespective of in Master Plan, the area was marked as residential area, they continue to carry out the commercial activities. So, my lords, this Honorable Court directed the BBMP to take action against them. Similarly, my lords, one more writ petition was filed. In 2008, my lords, which is produced at page number 132, annexure D, my lords. Plus, the batch matters, my lords, were pertaining to the same activities, my lords, wherein the BBMP continued to allow carrying out of commercial activities, my lords, in residential zones, my lords. There, my lords, this Honorable Court, my lords, has passed an interim order, my lords, which my lords will find at page number 137, which has been extracted.
But then they will act as per the master plan of 2015.
My lords, they are not doing it, my lords. I have produced the license plan, my lords.
You can't bring such a general petition. If individual instances of violation is there, you file a.
My loss, at annexure H, my loss, I have produced the licenses, my loss, which have been issued by the BBMP, my loss, to carry out commercial activities in Sadashivanagara. My loss, Malleshwaram, my loss, has been identified as residential main area, my loss. As per the zonal regulations, only 20% of the total built-up area can be allowed for commercial activities, my loss, only for the purposes which have been mentioned. In Sadashivanagara, my loss, only C2 activities have been allowed, my loss. If I may draw my loss attention to the zonal regulations, my loss, at page number 75, my loss will find what are the commercial activities which can be allowed. There's a table, which has been specified, which categorically deals with C1, C2, C3, and C4, C5, Residential, our area, has been marked as residential main, and only C2 activities are allowed. If see, the licenses which I have produced at annexure H, at page number 182, even the restaurants are allowed to carry out activities, in my area, which is not permissible, as per their own zonal regulations, which falls under the category of C3, trade licenses which are being issued by the BBMP, in Contempt.
Which was the other petition?
At annexure D, I have produced it.
What is that?
This was filed by all the similarly situated societies, constrained by allowing of the activities of commercial activities in zonal residential areas. Page number 132, I'm also the petitioner number 3 in that writ petition, In this writ petition, this Honorable Court directed with a interim order to the respondent, not to allow commercial activities in residential areas or residential mixed areas, After that, BBMP has appeared and filed a report and also undertook to withdraw any licenses which have been issued for carrying out commercial activities in the residential and residential mixed areas.
So the amended plan was notified or not subsequently?
It has been notified.
Then everything is step by step taken care of. Now today you are too general to contend before the court that there is a violation.
Even in the zonal regulations, only commercial activities can be permitted only up to only 20% of the built-up area can be used,
It is all right, but if there is an individual violation, you come to the court.
I have mentioned before.
Not by this public interest petition.
I have mentioned, I have produced before my laws several trade licenses, which have been issued. At annexure H, my laws may kindly see. I have produced my laws 4 trade licenses, And this is the conduct, in which they are allowing, permitting for carrying out of commercial activities in the residential main area, On previous occasion also, they have conducted a survey and submitted reports. Plus at page number 177, I've extracted so many activities, commercial activities which have been done, in the residential main area. I've given the representations to the BBMP, asking them to take action as per the direction of this Honorable Court, passed in the first writ petition and the second writ petition produced before my laws. No action has been taken, And they are continuing to issue trade licenses, which are produced at annexure H, So I have filed the writ petition, seeking to direct them to conduct a survey, and submit report. In fact, my lords, BBMP has undertaken to withdraw all the trade licenses which he has issued, my lords, in the residential area to commercial activities, my lords. That they have not done, my lords. So I'm seeking, my lords, to direct the respondents to conduct a survey, my lords, and file a report, my lords. Plus at page number 138, if I might draw my loss indulgence. Wherein, my lords, this honorable court has said, my lords. May I, my lord?
Or learned advocate, Mr. We are not convinced. You go if the individual violations is there, we'll permit you to approach the authority. Which authority?
BBMP, respond number 3.
Is corporation or Nagarpalika? Which?
Plus, may I seek for short accommodation, my lords? I will convince my lords.
Floor only. Yes.
I will seek for short accommodation, my lords. I will submit, my lords, whatever the necessary, if at all, my lords. Because, my lords, earlier in the writ petition, if I may take only 30 seconds of my lords,
What will you do after seeking time?
My lords, I will submit, my lords, necessary things, my lords. I will bring it to my lords and my lords why this petition is maintained.
Bring notice to the authority, not to us.
Plus, may I draw my lords attention? Only 30 seconds, my lords. May I have, my lords? My lords, at page number 138, my lords may kindly see. The interim order, my lords, has been extracted by this honorable court, my lords, wherein 138, my lords, internal page number. This is the order passed by the honorable High Court, my lords, in the petition. My lords, I am reading the second paragraph, my lords, from 9th line, my lords, in the second paragraph, wherein it is mentioned, my lords, we direct that the following areas of the city, that is Malleshwaram, wherein, my lords, Sadashivanagara also falls, Richmond Town, Vasantanagara, Vijayanagara, Jayanagara, Vishweshwarapura, Rajajinagara, Artinagara, etc., classified in the zonal regulations, which corresponds to the area which wherein purely residential area is permitted, no further permission shall be granted to redevelopment and reconstruction except for the residential user. My lords, BBMP has undertaken, my lords, that in compliance with this order, my lords, they will formulate the zonal regulation, and accordingly they have formulated the zonal regulation, my lords. Even in the revised master plan, my lords, they do not have the permission, my lords, to allow commercial activities in the residential area, my lords. They have specifically said, my lords, my area specifically falls under the residential main area, my lords, wherein, my lords, as per the zonal regulation and master revised plan, my lords, even commercial activities cannot be allowed. There, my lords, they are permitting, my lords, which have produced at Annexure H, my lords, all the trade licenses which they have issued.
Or learned advocate, Mr. What is your name? Praveen? HP.
Prashant Kamar.
Prashant.
Please. Prashant Kamar.
For learned advocate, Praveen SP for the petitioner and learned, who appears learned? Additional government leader, Ms. Nilofer Akbar for the respondent state and its authorities.
I appear for respondent 3 and 4.
For
Syed Shahrukh for SH
Third.
Prashant.
Bangalore Nagarpalika.
Yes, my lords.
The petitioner Sadashiv Nagar Residents Welfare Association paragraph has filed this petition in the nature of public interest petition in which several interconnected prayers are advanced. First is to direct respond number 1 to 4 to implement the provisions of the Karnataka Municipal Corporations Act and revised Master Plan 2015 by restricting the commercial activities carried out in the buildings and various buildings and sites. It is further read to require the respondent authorities to hear the objections of the petitioner while permitting any commercial activities in the Sadashiv Nagar area. Which comprises the Sadashiv Nagar, Raj Mahal extension, upper place orchards, etc. It is also the prayer to establish a citizen grievance cell to promptly address the grievances of such nature. The petitioners pray to direct the authorities to take appropriate action in the above regard, in light of the directions issued by this court in previous writ petitions, which were writ petition number 403 of 2006 and writ petition number 43472, dash 43474 of 2011. On going through the readings and the record of the paragraph petition, the prayers made in different forms are all centripetal to the orders passed by this court in the earlier writ petitions, which were filed by the same petitioner association. Writ petition paragraph number 403 of 2006 came to be disposed of by the coordinate bench of this court as per order dated 2nd August 2011. It was also a public interest litigation in which the similar kind of violations were complained of. The status report filed by the Brahad Bangalore Mahanagarpalika Independent BBMP bracket or which was placed on record, was considered by the court to notice that the there were three groups of violators. The first group comprised of persons who had been using the residential buildings for commercial purpose. However, they have since then stopped the commercial activities and restored the premises to the authorized residential use. The court concluded that in respect of this category, no action was called for. Paragraph. The second group was of the persons who had converted their residential buildings into used for commercial purpose without any permission. It was recorded that Master Plan 2015 was implemented, and thereunder the said residential premises could be put to commercial use. In view of the revised, full stop, in view of the revised master plan, comma, the court stated that in respect of this category also, no action was needed to be taken. The third was a category where the building was used unauthorizedly for buildings or sites were used for commercial purposes unauthorizedly without permission. It was recorded that this class of persons, this class of violators could not take advantage of the provisions of the master plan, as there was no such permission there was no such provision to permit them to use the premises illegally for the purpose other than the residential. Paragraph. The competent authorities, in the said petition, assured the court that all such unauthorized commercial uses will be stopped, and the action would be taken against the violators. The petition was disposed of accordingly. Another petition, paragraph followed, in which the very petitioner sought to assail the revised master plan 2015 formulated by BBMP as also the master plan approved by the state government. Noticing the provisions of the master plan and the approval thereof, as well as taking into account the contents of the affidavit filed by the Commissioner of the Corporation, the court observed that the complaints made with regard to the unauthorized use of the buildings and sites should be considered in light of the zoning regulations, and that the state government shall consider the same by notifying the proposed amendment in the master plan within 3 months. The said public interest petition was accordingly disposed of. The present one paragraph is a third in a row where the same grievance is raised about unauthorized commercial use of the residential buildings and sites. The pleadings invariably suggest that the allegations are too general and non-specific to be countenanced for the purpose of any relief. The master plan 2015 as revised and approved by the BBMP and approved by the state government is in operation for its provisions. It regulates the nature and kind of use of the buildings and sites in the area. In absence of paragraph, any specific instances having been avoided, and in absence of any specific instances having been given in the petition to suggest that a particular building is used in violation of the provision of master plan and the user is changed, the court is not inclined to entertain the vague public interest petition. Vague petition, the nature of public interest petition. Paragraph. The court is not inclined to proceed on the footing that the respondent BBMP or as a matter of fact, any of the respondent authorities are not alive to their duties under the provisions of the statute, or that they would not be implementing the master plan provisions. Paragraph. While the court is not entertaining the present petition for the prayers made therein, it is observed that if any individual instance of violation of the master plan with regard to the nature of user of any building or site is noticed by the petitioner association, it will be open for the petitioner to point out to the competent authority, the BBMP, which shall be attended to by the authorities by taking appropriate action in accordance with law. Subject to the limited observation as above, the present petition is dismissed.
Number 10, the Tejas KB.
What
Sir,
is it?
I appear on behalf of petitioner. And I would like to make a submission that respondent number 1,
Who are you?
sir, I'm from the petitioner.
You are a builder.
No, sir.
So who are you?
I'm a petitioner, a simple agent, real estate agent.
You are a real estate agent. And what you are objecting to?
Sir, my objection is that the respondent number 1 and respondent number 2, both of them have violated the RERA Act.
He respondent is your competitor.
No, sir.
Then who is he? Who is respondent?
Sir, respondent number 1 is a authority who is.
Let us see your, who are you? Let us, first of all,
Sir, please.
see
refer
your
to-
locus.
Sir, yeah. Annexure A.
So you are a partnership firm.
Yes, sir. A real estate registered agent.
What is your grievance?
So my grievance is that without having a proper requisite approval, the respondent number 1 has granted a registration certificate to the respondent number 2. And
Respondent
those
number 2.
environmental clearance.
Respondent
and-
number 2 is in
is-
the same field of.
Is a
real
builder.
estate- Real estate.
Yes, sir. There is a real estate builder.
And you are also engaged in the real estate business.
Yes, sir.
Correct. So what is the public interest involved in this petition?
Pardon, sir?
What is the public interest involved in this petition?
Sir,
This
it
is purely a private interest petition.
Sure, sir. So without having a proper approvals of environment
For
clearance.
their
and-
public interest litigation doesn't lie. You go before the authority and complain that this number 2 is violating this.
Sir, we have already done, sir. And
Even then, public interest will not lie.
so there are almost more than 10,000 people are getting.
We are not
deprived
inclined,
of-
mister. This is purely a personal private interest litigation directed against your competitor in the field. So if you are willing to invite the order, we are ready to pass the order, which will be coupled with heavy cost. You decide now. Option is yours, either to invite the order or not to pursue the petition. We are very clear from the beginning. This is a purely personal interest petition with no element of public interest. What do you want to do now? Tell us.
Sir, can I have a 15 minutes, sir? We have already, on 25th of March, 2024, we have already.
Now you
filed
make
a-
up your mind, do you want to argue the matter and invite the order, or you want not to prosecute? You are making us loud and clear.
Fair enough, sir. If your ownership is thinking that this is just a personal interest, we can dispose of. I can take that case. I'll take my.
Dismissed with cost of rupees 25,000. We'll pass the order, reasoned order, yes.
This is seal number 11, Mahesh V.
Appear for the petitioner's counsel, my lord.
This is that contempt.
Not my lord. Not. Item number 11, my lord.
11. Yes.
My lord, Kodagu district in Karnataka state is known as Switzerland of India. Earlier it was called as Coorg. It was a sea state earlier. After 1956, it is formed as it is merged with Karnataka and it is a district. In Madikeri town, which is capital of Kodagu, my lord,
6 kilometers from Madikeri, there is a place called K. Nudugune. The petitioner is the member of the panchayat of this K. Nudugune. From this K. Nudugune, 13 kilometers away, there is a scenic spot called Mandalpatti. The tourists come there and tourists take part, see the scenic beauty, and they come back in the evening. Similarly, there is another scenic beauty called Abbi Falls, which is a wonderful falls where during the rainy season, people come. About 100 jeep drivers park the jeep in a very tipsy-turvy manner, in a very erratic manner, in the middle of the road, inviting the tourist people and preventing them not to go ahead and threatening them to take the jeep and go to the scenic beauty and charge them heavily. And they don't allow the tourist to take the vehicle. And these are the things which the police have to regulate, my lord. And they are not keeping the vehicle in a uniformed manner, in a disciplined manner, in a jeep stand which is kept for there. It is only to prevent the others from going away to these two tourist spots. So we made represent to all the authorities.
What is this yellow board jeep driver?
Yellow taxi jeep drivers.
Taxi.
Yellow board is taxi jeep drivers. Your lordship may kindly see annexure A, my lord, the photographs at page number 27. And A2 blocking the road and virtually a gundaism, my lord. The people representatives.
This area is under panchayat.
Panchayat.
You are a member of panchayat.
Panchayat has passed a resolution.
My lord, the
Panchayat-
first ground may be seen, my lord, the first ground. Paragraph 10. Member of a Gram Panchayat is expressing his helplessness to implement their own resolution.
We have given.
You can file this petition only after resigning as a member of the panchayat.
No, my submission is only this, my lord. I came to this honorable court.
You flagged your issue there in panchayat. Your panchayat can take action.
My lord, section 70.
Only the police have to take a, police have to regulate, my lord. I came to single bench, my lord. Your lordship, this honorable court on 11th of July 2024. Page number 58, the petitioner is seeking to espouse a public cause. Therefore, writ petition in its present form cannot be maintained, reserving liberty to the petitioner to file a public interest litigation.
Where you are reading?
Writ petition is dismissed.
Where you are reading?
Page number 57, my lord.
57.
Annexure E.
Maybe.
My submission is only this, my lord. The panchayat has passed a resolution. The resolution has been forwarded to the authorities. The authorities have not taken any action. And this illegality is continued.
Which authority?
Authorities, the deputy commissioner, superintendent of police, and the RTO, road, road transport officer. Jilla Panchayat.
My lord, section 72(2) of the Karnataka Gram Swaraj and Panchayat Raj Act may be seen, my lord.
Every now and then court cannot be dragged. Every small matter.
They themselves have the power to remove.
You have power. Panchayat. That is what we earlier said. Panchayat can take action.
Police protection, if we get, my lord, if the authorities give, we can do it. They also don't come because these people are very powerful. With that observation, it may be disposed, my lord.
What observation?
That authorities can give protection to us.
Provided they approach the authorities.
No, we have approached the authority. We have given representation. Page, we have came to this court. On page 59, annexure F may be seen. We have done everything, my lord. My humble submission, let there be a direction, my lord. Then authorities, if they give the protection, we will, from the panchayat also, we will ensure that law and order is maintained, my lord.
They give it on 1st of July. My lord, and the writ petition is filed on 22nd July.
It is it is disposed on 11th of July 2024. 16th July, we have given the representation.
So which is the tourist place?
Madikeri, my lord.
Madikeri.
In Madikeri, there are about 40 tourist spots, my lord. The most sought after tourist spot is this Mandalpatti. It is on the top of the hill, greenery with a very precious flowers. It is a scenic beauty. People come there. They are not allowed to take the car. If the cars are taken by the tourist, after some jeep will go and hit the car and they cause damage to the car. Virtually a Gundaism, my lord, in this particular area.
In the present petition, filed as public interest litigation, the grievance sought to be raised is that at the tourist place called Madikeri, there has been a nuisance of taxi jeep vehicles. It is stated that it is claimed that the taxis known as yellow board vehicles are parked at Nandi Mote, NNDI junction of Hebatgiri, Hebbetagiri village of Madikeri Taluka. The taxis are parked on the road to pick up the tourist from Nandi Mote junction to Mandalpatti, Mandalpatti, MNDLPATTI. And that the parking of the vehicles on the road, and that the parking of the vehicles on the road not only blocks the road but becomes obstructive to other vehicular and pedestrian traffic. With such premise pleaded, the prayer is made to direct the respondents to implement the resolution dated 1/7/24 passed by the Nidugane Gram Panchayat. It is further prayed to direct the respondents to monitor the vehicle movement towards Madalpatti and the Madalpatti from Nandi Mote junction. The petitioner here in paragraph is a member of the Panchayat, which has passed the resolution dated 1/7/24. The prayer, as mentioned above, is to implement the Panchayat resolution. When learned counsel for the petitioner was Mr. So-and-so was confronted with the query as to why the petitioner, being member of Panchayat, could not flag the grievance through the Panchayat, whom he was entirely at his receiving end. Paragraph. As rightly prayed for, the function of monitoring the vehicle movement on the roads at any place is the task of the authorities and not of the court. When the court was not inclined to entertain the present public interest litigation, the present petition, a learned advocate for the petitioner submitted that in that eventuality, the petition may be permitted to approach the higher authorities who have not been acting despite the resolution of the panchayat. Learned additional government advocate had no objection if the petitioner approaches the authorities with his grievance. Full stop. Reserving such liberty, the present petition is dismissed.
Dismissed, no, disposed maybe. Dismiss means they will not consider at all, authorities, yes. Just disposed.
Dispose of is dismissed.
Dispose. Some problem in Karnataka.
Dismissed is dismissed. We are not inclined.
Dismiss, dispose.
Giving you the liberty to approach, it is dismissed.
Please.
See number 12.
For the
Sir,
petitioner, my
Who moved over petition?
It is regarding implementation of the orders passed by this honorable court, my lord. The affidavits have been
This
filed. by the-
pertains to, my lord, a direction to the government, my lord, to comply with the orders, directions and judgments of this honorable court. My lord, I have filed an additional affidavit, my lord, on 31/7/2024.
Is filed on which date?
31st, my lord, it's filed on 1st of August 2024. It's dated 31/7, filed on 1st of August.
31/7, yeah.
My lord, the government.
In fact, essentially what we want is
That the orders are compliant.
creation of kind of a cell
Yes,
in each of the government department, which will receive the orders of the court, assess the directions, and ensure the time-bound implementation
yes,
to reduce the inflow of the contempt petition.
yes.
That is what we want, and we want the directions to be issued in that line.
My lord, we have.
How every department of the government may have a cell comprising of the team of officers,
Yeah.
which will receive the orders of the court, which are to be implemented, and ensure that they are implemented within the time bound as directed, so that the contempt litigation is considerably reduced. So we'll go through this and then assist on that line on next day.
Very well.
That is the only idea of this CO mode.
But
No.
with the, my lord, with the enactment of the Karnataka conduct of government
So
litigation.
simple orders of deciding representations are not attended to.
No, I understand.
For 1 year and 1.5 years.
My lord, I'll have a word with the learned advocate general and make my submission.
Lord, they are referring to one particular legislation, my lord.
What you said in this last affidavit?
My lord, I have brought to the notice of my lords the enactment of the Karnataka conduct of government
There is
litigation.
an act also, no?
Yes, yes, my lord. I provided a copy of
That
that.
particular act will not address this particular issue, my lord. This is my submission, my lord. I have last occasion.
There was a section
There is a section 73, my lord.
which can come to their help to.
Yes, my lord.
to
We
evolve
have to
the
take note of section 73, my lord. On the basis of that 73, my lord.
Section 70.
That is available in the affidavit which has been filed, my lord. At page number,
45.
yes, my lord, 46, it is available. It is under the chapter
Oh.
12, my lord, miscellaneous.
Duties of the.
Yes, my lord.
deputy
Subsection 4, my lord.
Give the head of the department. Power to issue directions. Also, all these sections
Yes,
may
my
be
lord.
employed to create a kind of a machinery to
the deputy commissioner is made in charge of all the department, my lord. But my submission is that, my lord, the deputy commissioner cannot be the person who can deal with all these issues. As rightly observed by my lords, that in each department there should be a separate cell that can be taken clue from this particular section 73. My submission is that.
73.
Yes, my lord. Section 73, subsection 4, my lord.
Yes.
On receipt of the information on the pending execution cases, the deputy commissioner shall immediately make every necessary effort to ensure that court decrees are complied with and avoid unnecessary embarrassment of having movables of the government offices attached and sold in auction. Then, my lord, inform the head of the department concerned about the decree requesting him to take steps to satisfy the decree. My lord, there are totally 12 chapters in this particular act, my lord. It deals with the this legislation deals with the, sorry.
You must be getting several decrees from the civil court also.
Yes, yes, madam. Yes, yes. That's why this act was enacted. My lord, I'll have a discussion with the learned advocate general. My lord may grant me some time and I'll get back to my lords with the.
My lord, this legislation deals with the MSCT cases, my lord, land acquisition cases, criminal cases, various other cases.
No,
Whereas
this
with
is-
respect of the read petition, my lord, there is no separate chapter.
The word is, as rightly pointed out by my brother,
Yes, ma'am.
on receipt of the information on the pending execution cases.
Yes.
Will cover the entire range of orders.
Yes, my lord.
They're passed by the High Court or Civil
Yes,
Court, which
yes.
are required to be implemented,
Yes.
time bound.
Yes. But only thing is that, my lord, the separate cell has to be created, and that particular separate cell, my lord, in BBMP has also filed an affidavit, my lord. What they are saying that they have a court cases management system they have evolved. That is the ecosystem they have evolved. That has to be extended with respect of implementation of the order.
General system, we want in each department a kind of
Yes, my lord.
group of officers or cell, which will attend the pending executing of the.
And it should not stop at the stage of the disposal, my lord. It should continue. That system should continue.
To be taken to logical end.
Yes, my lord. Till the logical end, the key case reaches the logical end.
Yes, madam.
Work out on that line.
Yes,
The
yes.
presence of learned advocate.
Yes.
When shall we?
My lord,
21st,
2 weeks, my lord,
21st.
21st. Very well.
21st or 22nd, whatever.
Very well. Any date with my lord.
22nd of August.
Yes.
Obliged.
13 urgent, writ appeal matter, seal number 14.
I remember. 14.
Challenge the
How come?
single judge order before this honorable court.
What about the? 14 ZJ.
I am appear for the appellant, my lord. Petitioner filed this writ petition before the single judge that was dismissed on 30th October 2023. After getting the certificate copy, they have filed the writ appeal, challenge the single judge order. It is government land.
My lord,
6/1,
paragraph 8 is,
survey number
yeah, my lord.
8
of-
occurs.
Paragraph 8 of the order of the learned single judge.
8. In light of the submission made by the learned.
The entries are based on registered sale deed.
Registered sale deed by law. It is registered sale deed. The contention of the single judge is that way it is private land. Therefore, we are not interfering the order of the deputy commissioner. But the deputy commissioner order, that is, I have produced the sale deed, that is, I have produced the sale deed, that is annexer. Annexer Z. Annexer Z, it is the sale deed. But in the sale deed, it is stated that, my lord, they have land was granted in favor of the seller of the father. My lord, that is para number 2. Page number 2.
Whereas the land survey number 26/1 of the Basanpura village, Krishnapura Hobli, Bangalore Taluka, Bangalore has originally allotted to Sri R.K. Muthukrishna, son of R. Karnappa, as per the Sagoli Chiti issued by the Tahsildar Bangalore South Taluka, Bangalore 28/10/1966, as per the government order so and so. Evidence in the land, R.K. Muthukrishna was enjoying the above said land till his lifetime. The said R.K. Muthukrishna died intestate. After the demise of the land, R.K. Muthukrishna, the vendors herein have inherited the above said land, which is more fully described in the schedule herein under. The khata of the absolute property stands in the name of vendor rupees numbers 1 and 2 as per the MR number 3 of 2004-5. The vendors have paid the tax to the concerned authorities. They himself is admitted that Malak, the land was granted in their favor. Before getting this sale deed, the Lebanese sketch was not issued by the authority. That is the state that Malad, the Lebanese sketch was not issued by the authority.
Sale deed is in whose favor?
Whose favor, my lord?
Is
That is
Meenakshi-
response number
Meenakshi-
7.
Meenakshi.
Chandra. Response number 7. Chandra. The response number 5, 6, that is the sold the property to the Chandra. Their intention that the property is granted their fathers, in favor of the fathers. It is not private land, it is granted land. Moreover, the annexer, that is
Suit is also pending.
suit also pending, my lord. That is the same land was granted in favor. That is injunction was dismissed, filed by the respondent number 5 and 6. The FIR was registered against the sellers because of they not getting the Lebanese sketch and advantage of the sale deed disturbance the position of the petitioner's land. The authorities clearly said that, my lord, they have not issued the Lebanese sketch. Without getting the Lebanese sketch, the registered was done. And sub-register was initiated the proceedings under section 82-83 against the, that is purchaser and seller, that is wide annexer. Why?
Where is the order dated?
X.
Where is the order dated 5/1/21? Passed by the deputy commissioner.
My lord,
That is
Page.
page
page, my lord, that is annexer Q. Annexer Q,
Page.
that is
189, my lord.
180. Annexer Q, 189, my lord, 189. The purely the dismissed the deputy commissioner only on the ground that, my lord, original suit is pending before the lower court between the appellant and respondent. Hence, he unable to pass the orders in this regard. 189. I read the para number.
My lord, page 191, paragraph 7.
7. Paragraph 7. Yes, I have carefully, paragraph 7. I have carefully pursued the pleadings in the memorandum of revision petition and the documents produced by the petitioner and the contention taken by the fifth respondent in the statement of the objections and the documents produced by him and also the observation and findings of the first respondent in its imputed order. Admittedly, as admitted by the petitioner, imputed mutation orders have been passed by the second respondent and the same have been confirmed by the first respondent was on the basis of the registered documents. The revenue authorities have no other option but to accept the mutations on the basis of the registered documents, and hence the second respondent has rightly effected the imputed mutations and rightly confirmed by the first respondent. The revenue courts have no jurisdiction to adjudicate the legality of or otherwise of the registered documents, and the same.
Mr. It is based on the,
Mr.
Counsel, it is-
Competent to the civil court.
the mutation is based on the registered sale deed.
Yeah.
Registered sale deed, before registered sale deed.
Kindly listen.
Yes.
In favor of
Respondent number
Number
7.
Five.
5,
Original 5.
original 5 seller.
And your suit is pending.
No, my lord. That is not my case, my lord. That is not the injunction. Suit was only for the injunctions. Previously, they are filed the injunction that was dismissed. I have produced the order copy also. They are not in the position.
If you are
The
claim-
same, the question is my humbly submission that, my lord. The question is that, my lord, the seller of the father is the grantee or petitioner is the grantee. It is the question, my lord. The same land was granted to the petitioners. I have produced the MR number, that is 16/78/79. From the date of grant, the petitioner is in the position annexure A. That is not disputed. Annexure A.
Annexure
A.
A.
Annexure A.
That
Page number, that is 50, translated copy, that is 54/55, my lord. MR number
but
16, 17 and 80.
mutation based on the registered sale deed has to stand.
No, my lord, it is the petitioners, the granted land. It
Until
is
you get-
granted land in favor of the petitioners.
Until you establish your right in the civil suit.
No, my lord, it is.
They're
it is
pending
this-
or you may.
No, my lord, it is not the civil dispute, my lord. It is not the civil dispute. It is the writ petition. In the writ petition, whatever it may be, MR made by the, that is the seller in favor of that was dismissed. That is, I have produced the writ petition also. The MR number 3 of the 2004 and 5 also set aside by the Honorable High Court. That I have produced the writ petition copy. That is annexure, my lord. And the same land was granted against the father, that is tribunal, that is annexure D, in favor of the Meenakshama. On that basis, my lord, the writ petition was dismissed, filed by the, that is seller. All the mutation entries made by the Tahsildar was set aside, my lord. Is annexure, that is annexure, that is 144, annexure M, my lord. That is 144. All the MRs which was issued by the Tahsildar in favor of the, that is Muthukrishna's successor, that is RK Muthukrishna's successor Rukmini and Ramurthy, that was set aside. The Assistant Commissioner order was upheld by the writ petition. That is 144, my lord. As I may read the 144. It is 20,000 rupees cost imposing the, that is petitioners, and dismiss the writ petition. And ignoring the writ petition order, there is no mutation in favor of the sellers.
What is your good name? Danappa.
P. Panibhatya, my lord.
Huh?
Panibhatya, my lord.
Panibhatya.
Panibhatya.
So kindly listen now the order.
Kindly, my lord.
We have listened you, you listen the order. Listen to the order. We are not inclined. We are not inclined. Our learned advocate, Mr. It is very clear, Mr. But
No, my lord, it is private land. That writ petition, in the writ petition, it is said that it is private land. It is not private land, my lord. Its suit is pending for the only purpose of injunction, my lord. The previously respondent has filed the injunction, dismissed. I have that also produced before this court. Yet they are not in the position. Dispute is only grant by this same land is granted in for the petitioner or respondent. That is the main question, my lord. It is decided by the deputy commissioner, not in the original suit, my lord. That is the question. Already the mutation entry is also set aside by the Honorable High Court in writ petition, my lord. And Lebanese sketch was not issued by the authority. The FIR was registered against the respondents, 7 and 5 and 6. And section 82-83 Sub-Register Act also initiated the proceedings. They are unable to cancel the sale deed. Getting the sale deed advantage, they disturbance to my possession, my lord. I am also owner, granted in favor of me. And where my land? That is my question.
that is all.
There is no grievance against the respondent number 7, my lord. The unless until they issued the pani, I have not proved the land to show that I am in the position. And moreover, in the year of 2006, I am in the position, said the sketch map. I also produced the petitioners in the position of the land. That is sketch map. I have produced the annexer. Annexer C. I am in the position of the land. That is 26/1. I have produced the translated copy. That is 60 page number. The aforesaid sketch LNDSR 417-78-17 as per the Saguli Chitti order 4 acres of land in favor of the Srimati M. Narayanamma, wife of G. Hanmantappa. The sketch prepared as per the order of the Honorable Special Deputy Commissioner, wide order number so and so, 31st/8/1978, which is confirmed, and hence the sketch prepared.
Our learned advocate, Mr. Nanappa Pradhanappa Rani Bhate, for the appellant, and learned additional advocate Srimati Nilofer Akbar, upon service of the copy of the appeal in advance. The present paragraph, the writ appeal under section 4 of the Karnataka High Court Act 1964 is directed against judgment and order dated 30th October 23, passed by learned single judge, dismissing the writ petition. In the writ petition paragraph filed by the appellant petitioner, what was prayed was to set aside order dated 5/1/21 passed by the Deputy Commissioner in revision petition number 118 of 20. Further prayer was to direct the respondent number 1 to 4 to consider the representation dated 19/8/2020 submitted by the petitioner in relation to the subject matter grievance. In the petitioner paragraph, the dispute center rounds the mutation entry in respect of land property survey number 26/1 at measuring 4 acres situated at Paswanapura village, KR Pura Hobli, Bengaluru East Taluka. The petitioner claims to be the owner of the said property. At the same time, it appears that the very property came to be sold to one Sri R. Chandra, respondent number 5, in the proceedings of revision before the Deputy Commissioner by respondent 3 and 4. Under a registered sale deed dated 25/11/13. Full stop. On the page of the registered sale deed, mutation entry was effected in the name of the purchaser, that's the 5th respondent, by the competent authority, that's Assistant Commissioner. Paragraph. It was the aforesaid order of the Assistant Commissioner which was challenged by the petitioner appellant before the Deputy Commissioner by filing revision application. The Deputy Commissioner inter alia took view that it did not have the jurisdiction to adjudicate the legality of the entry once it is pursuant to registered sale deed. It was observed that the jurisdiction would lie with the competent civil court, even if the petitioner was claiming the ownership of the land sold under the registered sale deed. With such reasoning, the revision application was dismissed. Paragraph. When the order of the deputy commissioner was challenged before a single judge in the writ petition, on a single judge noted that although the petitioner was claiming his rights over the land pursuant to a grant order, the mutation entry which was entered into in light of the registered sale deed between dispute number 3 to 4 and 5 could be altered only if the petitioner could establish his titular right over the property in a civil proceedings. Following reasoning was supplied by a single judge to dismiss the petition. On paragraph, on page 19, bracketed portion, quote, the petitioner hearing claims right over the, starting therefrom to in the revenue records. The aforesaid reasoning eminently informs the position of law that once the registered deed is executed, the mutation based on thereon would be justified and could not be altered unless the party establishes his right otherwise in the civil proceedings. It is to be noted as that original suit number 25588 of 17 instituted by the petitioners in respect of the very subject, in respect of the very property is pending. Although learned advocate, the petitioner tried to submit that the said suit is only for injunction, it is no answer to set at naught the mutation entry effected pursuant to a registered document. A single judge committed no error in upholding the order of the deputy commissioner in revision application confirming the mutation entry effected by the competent authority. The appeal stands meritless and the same is dismissed.
My lord, liberty, my lord, kindly one liberty, my lord. I am not disputing any. The grant was granted, the land was granted in favor of the petitioners. I seek the remedy to the before the deputy commissioner to issue the pani according to the MR. That is my prayer. That is liberty. That is liberty, my lord. I seek the remedy before the deputy commissioner.
So
according to the MR, the pani was issued. That is my remedy. That is my remedy.
If after this order any remedy is available other than civil suit, you can pursue.
Now, my lord, unless until we getting the pani, we not establish the lower court. That is my grievance, my lord.
You have to file a civil suit or amend this instance.
No, my lord, they said that it is a private land, but it is not private land, but it is grant land.
That you have to
The same land was granted to two persons.
That you have to establish. We are only concerned the mutation entry. It is only fiscal value.
My lord, liberty, my lord, I have approached this another writ petition.
Whatever extent or whatever title you are claiming, you have to establish in this process.
My lord, getting the pani, my lord, only on the basis of the MRA getting the pani. That is my remedy, my lord. Only remedy. If he issued the pani, I no problem.
We have limited comprehension. That is a
No, my lord. One liberty, my lord. One liberty. According to the annexure A, I will establish the rights. Remedy. That is one remedy.
And in this suit, there is no prayer to challenge the sale deed.
No, I am not challenging the sale deed, my lord.
State
I-
civil suit, even the prayer is made challenging, the prayer is made to set aside the sale deed executed between this one 3 to 4 and 5.
I'm not binding upon the sale deed, my lord. That injection, my lord, that is only injection.
No, there is a prayer in the suit of challenging sale deed.
My remedy is, unless it getting the pani from the authority, that is my remedy, my lord. The same land was granted to the respondent number 7. That is my grievance, my lord. That is granted land. That is not private land. It is private land. I go to the civil court. That is no problem. It is only decided by the deputy commissioner who is the grantee. That is my question, my lord. That's why I filed the writ petition. That question will be decided by the deputy commissioner clearly. Liberty, my lord. That is some liberty, my lord. According to the annexure A, consider my representation MR number and issued the pani.
Liberty is always there to file a civil suit.
Yes, my lord. A civil court, my lord. According to the MR, my lord, I get the pani, my lord. That is my grievance. They are not denied my title. They are not denied my grantee. They accepted I am the grantee, but pani was not issued. That is my grievance. Unless until we getting the pani, we not go to the survey. And also survey report also said that I am in the position. That also clear. But getting the advantage of the sale deed, they disposes my position with protection of police. That is my grievance. Kindly, my lord, it is scheduled caste community. The petitioner belongs to scheduled caste community. Protect his land. That is my grievance.
So applies to all equal.
My lord,
Everybody is equal as per our orders.
the equal, my lord, but I have remedy to get the pani from the authority, my lord. That is my grievance.
Sorry.
Number 15. KV
Nothing more, nothing less. Yes. Your appointment was for 3 years.
Yes, my lord. It was for 3 years.
Now you have consumed how many time? How much time?
My lord, it is
When you are
16/9/2022.
22. So
Yes,
it will
ma'am.
end in 25.
Yes,
So fresh process is started.
my lord.
Fresh process of appointing another government leader is started.
My lord, I have no instructions on.
Because your limited grievance is about
Yes.
direction number 3,
Yes, my lord.
direction number 4. Which says that petitioners will continue to discharge his service as additional government leader till fresh appointment is made.
My lord, I'll seek instructions. My lord may have this next week.
Yes. I have no instructions on this aspect.
So they will take.
Yep, obliged. Maybe date may be fixed, my lord.
28th of August.
Like,
Obliged.
Lord, senior counsel is engaged, seek for a passover, my lord. Engage
Why?
senior. I am engaged senior counsel, my lord. He is held up in court number 16. Lord, you may kindly pass it over.
And why senior counsel? There is a delay of 107 days.
Yeah, there is a delay, my lord.
To notice in delay application. Notice returnable on
Lord,
August 4 or September 4.
Lord, the 64 inquiry, my lord, on the basis of a letter by the minister, my lord, on the basis of minister, my lord, they are.
Until you cross the order of delay, nothing can be done.
So at least, my lord, not to precipitate the date. my
Without condoning delay, no.
lord. Earlier date, my lord.
Earlier date. 30th August.
Please.
December 17.
Appearing for the petition. This matter was set on for
For this Rajiv Gandhi?
Yes, my lord.
Day after tomorrow.
Obliged.
Number 18.
So the accused in this matter.
Number 18. Mr. H. Devendrappa.
Revision petition has been filed in this matter, Your Lordship. Review petition number 351 of 23. Review petition has been filed in this matter, Your Lordship, which is pending. Matter has to be called along with the review petition.
What is the
RP number 351 of.
What is the status of review petition?
Not yet listed, ma'am. Notice is also not issued in review petition.
No, we are asking the council, what is the status of review petition?
It has been filed, Your Lordship, it is not listed. Now both the matter has to be clubbed together so that it can.
Therefore, we are asking before for the purpose of clubbing only, what is the status?
It was
You
filed, it
just
has not
filed
come
and
up.
not pursuing then?
Yes, pursuant to the filing, it has not come up still here. Not even one.
What is the direction?
Podi and.
Podi and Duras.
Podi and Duras.
Respect to plan. The directions contained in the order of learned single judge dated 22nd August 22 in the writ petition, which are brought under the contempt jurisdiction, read as under page 15 and page 15, 1 to 5 direction. Also, when the contempt petition, when the present contempt petition comes up for consideration, learned additional government advocate Jafar Shah stated that the state has filed review application in respect of the order of learned single judge, which is review petition
Number 351 of 2023.
351 of
23.
2023.
Yes, Your Lord.
353. Full stop. It is evident that the review petition is filed before, at least before 1 year. Full stop. In the aforesaid review, it is observed that the state shall seek appropriate orders in the review application within 6 weeks.
Yes, obliged.
In which the implementation of the directions of learned single judge shall be adverted to by the authorities.
Obliged.
Put upon, we'll say 6 weeks means 19th September.
Obliged.
19 urgent, number 20. So Madhusudan Adigabi.
Appearing for the government, my lord.
Filed an application seeking for extension of time, my lord. There was a direction from this honorable court to conduct the survey, my lord. Thereafter, I had conducted the survey. I filed an interim report.
Very old matter. Who is the petitioner? What kind of action you are contemplating against the number 8?
My lord, the construction is in a regulated area of a nation protected monument, which is without permission.
So what action do you want?
I want the authorities directed to take action. I have submitted.
What kind of action? Demolition?
Demolition. That's
why?
Because it is constructed without permission and in a regulated area. They are not supposed to construct.
Number 8 itself is a ancient monument.
Yes, my lord, it is a national monument.
Number 8.
Protected national monument.
Number 8 is a protected monument.
Yes, my lord.
So then how can it be demolished?
No.
Around the
Construction
area.
of a private building in the protected area, not the national
Construction.
monument. Construction by a private body.
It is a construction of what?
A building, for what purpose they are constructed, we don't know. A huge building, my lord.
There is a temple or?
No, not a temple, not a masjid.
Masjid.
Not, my lord, it's not a masjid. They have constructed. It's not a masjid. I'll draw your lord's attention to the photographs, my lord. It's not a masjid, I saw. They have put up minars, but earlier there was no masjid in that place.
So we are filing report. Who is filing report?
My lord, I am supposed to.
The
file report.
archaeological.
I will put it like this.
Earlier, no report was.
I had filed a report, my lord. There was a direction from this honorable court to conduct the survey with respect of regulated area as well as prohibited area to ascertain what all other construction have come along with this particular property which is coming up, my lord. For that, my lord, I had submitted a report, my lord. Thereafter, in fact, my lord,
Go to page 228. This tower is part of the construction.
yes, my lord,
Tower.
yes, my lord, it is a minaret, my lord.
Ah.
Minaret will have an impact on this particular monument. my lord. That is the contention of the petitioner, that this particular minaret would affect the aesthetic value of this particular property, and without obtaining permission, they are putting up.
That monument is temple
Yes,
Yes, my lord.
or masjid.
No, temple.
Temple.
The temple, my lords, it was, name of the god is Saumya Keshava temple. Saumya Channakeshava temple it is. And it was established, it was constructed by the Hoysala ruler Vishnuvardhan.
It is been constructed within that prohibited or protected area,
Regulated area, regulated area.
regulated area.
It was constructed long back, my lord. Thereafter, it was declared as a protected monument. And
Yeah.
from that particular protected monument, my lord, in the regulated area, there is a minaret being constructed. my lord.
You are for archaeology.
Yes,
How this minaret can affect the,
They're not my lord, they're not supposed to construct. The Archaeology Survey of India agrees to that, my lord. That it is an illegal construction. They are not supposed to construct in that way. It's in 1000.
so it is within regulated area or prohibited
It is
area?
within the regulated area,
Within regulated. So not permissible.
not permissible. If they want to put up the construction, they have to take the permission.
It is permissible with permission.
Yes.
Yes, ma'am.
Yes,
That is the point.
yes.
The height should not exceed, my lord. So that the ancient hominid's prominence will get diminished. That is the essence.
In the earlier order, the court directed respondent number 5, Archaeological Survey of India, to submit a report as to, inter alia, as to whether the construction which is being put up by respondent number 8 is in violation of the norms regarding construction in the prohibited area or regulated area in the vicinity of the protected monument. It was submitted that the report is in the process and further time is required. Full stop.
I had sought, my lord, 1 month time, but I had filed
The
application
petition
only in the
shall be,
month of June.
the petition shall be next listed on 19th September. Time to submit report is extended till the next day.
Number 21,
Appearing for the respondent.
Mohammed Dastagir, party in person.
My lord, I am the party in person petitioner in this case, my lord. My lord, I had filed this writ petition challenging annexure A, which is a notification fixing fares for taxis. Annexure A is the notification fixing fares for taxis by respondent number 1. My lord, after filing of the writ petition,
two more notifications has been issued by respondent number one, which I am required to challenge in the very same writ petition.
Notice is issued.
No, my lord, my only submission is there have been subsequent notifications which have been passed. So this becomes infructuous.
My lord,
And-
this, may I make my submission?
And if I can just finish, my lord. And there is another writ petition PIL which has
Yes.
been filed by the Learned Counsel, which is of the year 24, wherein the subsequent notification has been challenged. So, my lord, this writ petition would only lead to multiplicity because this is of the year 2018 notification which is challenged. So let him challenge.
Which is that other petition, red petition?
That
My lord, that
is,
is
my lord, 692.
29 of 2024, that is
2024.
dated to be listed on 28th of August, my lord.
6929 of 24.
Please, my lord.
24, my lord.
So this would not survive because that will comprehensively deal with all these aspects. That the subsequent writ petition would comprehensively deal with all these aspects. So this writ petition would not survive for
May I make
consideration.
may I make my submission, my lord?
Where is the other subsequent notification?
That subsequent notification, my lord, the most recent is 3/2/2024.
So you are aggrieved by this 3/3/18 notification.
Please.
3/3/2018 notification. If I am permitted to make my submissions, my lord.
So now new
I
is.
have it
this
in
is-
Kannada, my lord.
This will not survive.
It will survive, my lord. Let me make my submission, my lord. After 2018 notification, my lord. Two more, no. My lord, I have produced that notification in the other writ petition. Let me make my humble submission whether this writ petition becomes infructuous or not, my lord.
So earlier notification provided for levying charges on the basis of the cost of the car.
Fixation of the fare with
On the
regard
basis
to
of
the,
Cost of the car.
depending on the cost of the car. Yes, my lord.
What is the logic?
My lord, there are various categories A to D, and based on the cost of the car, the fare is fixed. Because
Anyway, but now what is this new notification?
new notification, there is an increase in the fare fixation of the as per the aggregators. So the fare has increased.
As per the.
Aggregators, my lord. The aggregators are the fare fixation is done by aggregators. The aggregators are Uber and your app, my lord.
May I make my submission now, my lord?
But then nothing survives.
Let me make my submission, then I will leave it to my lord. My lord, after issue of the notification on 3/3/2018, two more notifications are issued, which I have produced along with my IFR amendment of the writ petition.
That
These notifications, my lord, do not rescind the earlier notification. They only modify the earlier notification. Therefore, my lord, my respectful submission is these subsequent notifications also need to be challenged in the present writ petition because these the original notification issued has to be set aside so that these notifications will go. Otherwise, my lord, the subsequent notifications do not have any legs to stand. And subsequent to this, my lord, another notification which is issued, I have challenged in another writ petition. Therefore, my lord, my humble request is let this IA be allowed so that I can submit my amended writ petition. And this writ petition can be clubbed along with that writ petition and both can be heard together.
What is IA?
My lord,
What is IA?
notice might have been
IA for
in
amendment.
2020 itself, my lord, order was passed.
What is IA is filed for what?
IA for amendment of the writ petition by producing the subsequent two notifications, my lord. Which I am also required to challenge in the very same notification because they are-
Pursuant to 2018, there was notification in the year 2021 and subsequently in the year 2024. Now, the amendment seeks to bring to the notice of this honorable court, the subsequent notifications of 21. Subsequently, there has been the recent notification which I've forwarded to your honorable lordship.
my lord, that notification also modifies 2018 notification. That is not in resign. That has not resigned at the earlier notification. It has only modified.
So therefore, the modification will be looked into.
My lord, all the notification will have to be considered together. Therefore, my humble request is let this IA be allowed or a notice be issued on this IA. When I file the amended writ petition, my lord, my humble request is both the writ petitions can be tagged together and heard because all the notifications have to be heard together, my lord.
They are saying some other similar petition is pending.
Yes, my lord, that is also filed by me, my lord.
54.
Club together and all.
Yes, my lord, yes. On 28/8, that is listed, this also may be listed on 28/8,
8/8.
28th of August.
It was stated that the writ petition involving the identical subject matter is slated to come upon 28th of August 2024. In that view, the present petition may also be listed together on the said date.
That is writ petition number 6929 of 24.
That they will consider whether to permit you to amend or not to amend.
Yes, my lord, yes, my lord. Obliged me.
Till number 22. After Subramanian Swami.
Yes, Your Lordship, we are at the
Number 3, permitted to file a rejoinder to the
Petition number 3, impleaded. Impleaded as petitioner.
Impleaded as.
We have impleaded.
Why the order dated 1/4/2020?
Your lordship, you hadn't actually decided on the impleading as a petitioner. So we had actually arrayed them as respondent 5. So in the daily order, while it's been raised as an office objection, you hadn't actually passed a conclusive order as to them being impleaded as petitioner 3. So we have
We'll
not
say that.
amended the petition.
Pardon?
And we've not amended the petition, but if your lordships were to direct, then we'll go accordingly and we undertake to do so. But at the moment,
I mean, order is part. Order dated 1/4/2023, 2024 months. My lords, on our order dated
That's right.
1/4/2023, serial
But,
number 6 of the order, my lords.
That's an error. We will not permit you to implead as petitioner. You can be a respondent.
Please, my lords, I will then,
Okay.
we are supporting the petition, my
Who
lords.
is it? You are there.
Please.
The learned additional advocate general will be appearing in this.
Better you file, either of the party may file not for speaking 2 minutes. We'll say you are permitted to implead as respondent number.
I'm supporting the
File the
petitioner, my lords. I might then have to seek for transposition. I'm supporting the petition, my lords, and I'm not taking any different view than the petitioner itself.
You can submit your, put for your case, but not as a petition.
Please, that order be amended. my
File the
lords, or,
application for implement, my lords, as a party in this petition.
In course of the hearing of the petition today, it was noticed that in order dated 4/1/4/24, passed in IA number 1 of 23, comma, the applicant, impleading applicant is permitted to be impleaded as petition number 3 in the main proceedings. Full stop. It is an error apparent on the face of the record. Therefore, the court sumo to withdraws the said order dated 1/4/23, and it is provided that for the reasons stated in the same order, for the very reasons stated in the same order, the petitioner shall be permitted, applicant shall be permitted to be implemented, however, as respondent number 5.
Another application,
Respondent
my
number, it goes
application
down
for
to-
implement is also there, my lord.
Whatever, you are there in whatever capacity. Your purpose of not a petition.
My lords,
My lords.
just bringing it to the court's notice, my lords. Respondent number 5, 6, 7, 8, 9 are already on record, my lords, the very same day order, if I'm not wrong.
That is an error. We are.
So I can be the respondent number
We are open to.
8 or 9. whatever.
Plus, I am respond number 5, my lords.
You have put us as 5, is it?
Plus, I am respond number 5.
A different number, respond number 5 to 8 or whatever.
My lord.
But I am respond number 5. I already filed my,
All will be permitted to be implemented, but as a respondent, not as a.
Yeah, but respondent, my
Respondent,
application is
yes.
pending before this today for hearing.
Yeah.
Yeah,
So it is granted, all impleading applications are granted, which are granted on 1/4/24. But the order is withdrawn and press order is passed to in today's date, impleading you as number 5, 6, 7, 8. Respondents.
I am respond number 5. I have already served copy of the statement of objection to the other side, to the petitioner.
Very good. Yes.
Your Lordship, I'm seeking really not to win this side or that side. What I'm seeking is a constructive way of setting up a commission to examine this in which all parties will be represented. And once that is done, the final matter can come before your Lordship. This is all that's my prayer. If I read my prayer with your permission, it will become absolutely clear that what I have said is issue a writ of mandamus or any other writ directing the respondents to formulate and execute a commission under the monitoring of this honorable court to consider the legitimate and rightful demands of the CNC for geopolitical autonomy and internal political self-determination rights under the Constitution of India. Now,
So
this
any
is
of, we'll consider, any of the newly added respondents would like to file their responses?
We will file our response, my lord.
Yeah.
What about the prayer advanced by learned party in person, Mr. Swami? About that?
We are objecting for the same, my lord.
You're objecting?
We are objecting for the same, my lord.
They're all
He also has filed
There
objections.
is no,
It will have to be heard.
objection. Yes.
It will have to be heard. After the pleadings are over, we'll.
Please, my lord.
Uh,
My lord.
Here, there is no injury to anybody. To have a commission to examine
there
it,
is pending in Supreme Court.
even to consider it, the government considers they're under threat, that they have to respond in this way. After all that we are doing is to save the time of the court and get some important people to look at this matter, and all of us come and give our suggestions and come across it. That's the way I would say in a democracy we proceed further.
We will deal with it legally.
We'll hear them before considering your.
Please, my
May
lord.
make one submission, my lord.
Yes.
Insofar as granting the gun license to the Kodava community, my lord, there was a petition pending before this honorable court.
We are not on that at all.
No, my lord, may make,
We are not involved in that. We are nowhere in that.
that matter is pending before the honorable apex court, and it is
Accept-
listed on 17/9/24. My lord, that may have some bearing on this matter also, my lord.
No, how can it? How can the
Cultural
rights
rights are
be
argued
affected by that?
But let the parties who are now impleaded file reply, then
Please.
we'll consider.
Please, my lord.
We'll give 3 weeks time to file reply, then we'll proceed with the matter.
I'll file written submissions with your permission, Your
You
Honor.
can file written submission as well.
Much obliged, much obliged.
A kind submission, my lord. An entire copy of the petition and the annexure to be served on us, my lord.
While learned party in person, Mr. Subramanian.
I will serve.
Submits that the request for interim order considered, the newly added respondents, the learned councils, respective council for the newly added respondents wants to file their response. Full stop. Time is granted up to 19th of September to file such response. The petition may be listed for,
It will be the same as just.
listed on
After 15th October, anytime,
after 15th of
October.
October.
17/9 is to a matter.
21st October,
Yes, Your Lordship.
as requested.
Meanwhile, we be permitted to file our
That is,
Sections are supporting statement.
yes, yes.
Maybe also serve on them on WhatsApp and email.
You can so, no?
By all modes.
Is permissible.
My
By all modes.
my lords,
When the Supreme Court matter is coming up,
17-9.
17-9.
so that subject matter is one of the prayer?
No,
No, they are urging
some
cultural
bearing on
rights
this
there.
matter, my lord.
They are urging cultural rights there in that petition and they want.
I know. That's it.
You want commission to be appointed under commission of inquiry, which, under which provision?
Yes,
Commission of inquiry.
it's permission 3 is.
So
Section
that-
3.
That law takes within the purview this subject, such subject matter also.
Yes, absolutely. Most welcome.
All that will consider.
I have one more request, my lords. Let the respondents serve the copies to the respondents also inter se, my lords, because they are divergent views opposing
Of
and
the pleadings.
so-
Please. Shall be served inter se because
inter se among the respondents also and can be by way of electronic.
the respective pleadings shall be served inter se in the interregnum.
By way of electronic mode, my lords, would be. Highly obliged, my lords.
Aye. That's the order.
Number 23. My lords, I appear for the appellant in this matter.
You appear
My
for-
lords, I have filed an IA for restoration of the writ appeal along with the interim order granted earlier. My lords, the issue is this. On 3rd of June 2024, my lords, the writ appeal, there was an order stating that any remaining office objections had to be complied with within a period of 4 weeks, barring which the writ appeal will stand dismissed, my lords. The only remaining office objection, my lords, was the non-production of 2 annexures, which had been filed by the petitioner in the main writ petition, my lords. These are annexures U and W, which in respect of which, my lords, I as the appellant had already informed the office that these were documents which were not provided to the appellant in the original writ petition. As a result of which we were unable to produce these at the time of filing. My lords, this office objection and the council submission was also recorded by the office in its order dated 14th of February. My lords will find this in page 5 of my IA, my lords. If I may be permitted to read from page 5, the petitioner in writ petition number 2791 of 2023, which is the respondent herein, did not serve copies of annexures U and W to the rejoinder. Hence, the appellant is unable to produce such document with the writ appeal, and this objection may be disposed of as sufficiently addressed. My lords, inadvertently, what has happened now is that this counsel submission, my lords, has been omitted by the office. Therefore, my lords, without considering the same, the writ appeal therefore came to be dismissed as per the order dated 3rd June 2024. My lords, our respectful submission is twofold. The first is that, my lords, we could not have produced these documents at the time of filing. The second, my lords, we've already filed a detailed counsel submission in respect of the non-compliance. Every other office objection, my lords, was complied with at the time of that date. And my lords, these two remaining documents have also been sought, my lords, from the counsel for the petitioner erstwhile.
Advocate Mr. So from petitioner, learned additional
Yeah.
government advocate Mr. Nilofer Akbar for respondent state and learned.
Appear
advocate
for
Mr.
respondent employee.
Number,
There's only one respondent.
Respondent employee.
which respondent?
Respondent number 1.
5,
No, 1.
1.
There's only one
It
respondent.
is a pension matter,
And
my
what-
lord.
You are appearing for whom, man?
State.
Don't appear, number 1. Full
It is
stop.
a
The
pension
present interim application is filed seeking restoration of the writ appeal number 69/24, which was dismissed for want of compliance of the office objections paragraph. The accompanying affidavit filed by the applicant spells out the reasons in detail as to why certain office objections in the nature of production of annexures could not be complied with despite the bona fide efforts on part of the applicant. In order to enable paragraph, learned advocate for the applicant would submit that the office objections which are left out shall now be removed within
My lords, we can remove it within the course of this week, my lords.
within the time with the court may grant, full stop, in order to enable the applicant to contest his case on merits rather than being thrown out on the technical ground. The present application is allowed by restoring writ appeal number 69/24 to its original files along with the orders subsisting therein on condition, however, that the left out, the remainder of his objections shall be removed within 2 weeks from today.
My lords. Deeply
Res-
grateful.
Respondent is present before the court.
Very good.
Comply.
So you
My
instruct
lords,
your respondent. We are
the
not
interim
concerned.
order may be restored as well. Deeply grateful.
It is matter for pension, my lordship.
The
pension.
respondent is present. Why you are mentioning that? For what purpose?
Present.
Don't make irrelevant submissions before this court.
Okay.
It is your client, you deal with him. Don't produce before the court in this fashion. Learn the etiquette of the court system. You're not supposed to produce your clients in this fashion for no purpose.
Number 24. This is also a restoration application. Restoring the writ appeal 769 of 2024
Yes.
on behalf of the applicant, because on 28th May 2024, there was an order to comply the objections within 3 weeks. And exactly I complied within 15/6. But
So this appeal is directed against which order? 7th of June,
28th May 2024, my lord,
20th May.
2024, when this court, honorable court directed to comply the office objections in 3 weeks.
No. This is what? Interim rule for restoration. 24. The recalling filed by the.
Restoration of the writ appeal number 769, which has been dismissed for non-compliance, my lord. Because on,
So
before,
I-
I complied all the objections before 15/6.
IA 4 of 24. So order, common order in IA 4 of 24 and IA 5 of 24. Third, learned advocate for the respective parties, full stop. Then say order in IA 4 of 24. This is an application seeking to condone the delay of 23 days, which has occurred in filing the recalling application. Full stop. For the reasons stated in the accompanying affidavit, sufficient cause is made out, explaining the delay of 23 days. Accordingly, it is condoned. Application is allowed. Then order in 5 of 24. In this application, what is prayed by the applicant is to restore the writ appeal, which was dismissed for want of removal of office objection. Full stop. In course of the hearing, learned advocate for the applicant stated that the applicant is applicant undertakes to remove the office objections within the time which now the court may grant. Paragraph, in order to enable the applicant to contest his case on merits rather than being thrown out on technical ground of office objections, the prayer is granted by restoring the writ appeal number 769/24 to its original file along with all subsisting orders therein, on condition that the remainder of his objections shall be removed within 2 weeks from today. Within 2 weeks.
Non-filing in contempt matter, cell number 25. For the complaint.
Pardon?
The accused in this matter, Your Lordship.
The government has to file, my lord, the compliance report.
In this matter, Your Lordship, the records were not available. The matter was referred to the missing committee to build up the records. By an order on 12/6, there is an order from the Tahsildar that the records have been built by the missing committee, and it's ordered by the ADLR to conduct the podium. 4 weeks time may be granted, they will conduct the.
But you file your some affidavit.
Obliges, I'll file the affidavit.
Learned additional government advocate submits that 4 weeks may be granted, within which the directions of learned single judge will be complied with. Any of the request and the statement, time is granted up to 9th of September, within which time it is expected that the directions will be complied with. Full stop on the next date, the compliance affidavit shall also be filed.
Number 26. With Leela P. Devadi.
Your Lordship, I appear for
In-
petition now.
in
Sorry,
this
my lord,
matter, Your
complainant.
Lordship.
My lord, in this matter, Your Lordship, after filing the contempt, Your Lordship, they filed an compliance affidavit wherein they stated that they have made the part payment of the timber value. Even thereafter, Your Lordship, they saw.
Now, the interest amount is balanced to be paid. A certain amount was paid for the timber, and only they have a claim on the interest. Now, for the approval of the interest amount, the requisition was sent to the financial department, which is in the process of approval, Your Lordship. In some time, we will have it paid. The interest part, the principal part of the timber has been paid already.
Your Lordship,
Principal part,
Principal part for the timber has already been paid. They have received
Your
48
Lordship,
lakh.
kindly see the order passed on 6/3/2023.
you
Very
filed
in-
something,
Pardon me?
you file your affidavit,
No, Lordship. not.
file it. How do we know that substantial compliance is there unless you file affidavit?
Obliged.
Learned additional government advocate shall file compliance affidavit. Shall file affidavit detailing the steps taken towards the implementation of the directions of learned single judge and the compliance thereof. Such affidavit shall be filed before the next date, put upon 3rd of September.
Grateful, my lord.
Number 27. P. N. Anjareddy.
Right, my ballot on 10th, Your Lordships. Lordships, I kindly have it on 12th. I will find out what is the current status, Your Lordships.
Well, at the request of learned respondents, 12th. Not 12th, then
Any other day,
20th.
please.
Number 28.
Counsel for
Suresh?
complainant, Your Honor.
28.
So last time itself, they have
I have-
taken time
I
to
have
file
filed
affidavit within 45 days.
I have
last
filed
weekend.
I have already filed an affidavit, my lord, stating that, my lord, the single judge's order was to allot an alternative site. We had identified an alternative site, my lord, we had prepared the sketch. But in lieu of, my lord, there was a temple there, and now, my lord, they are objecting to issue.
Same this thing they
They're
are
objecting
submitting.
to issue,
Last
my
time
lord. We
also.
are finding an alternative site. May I request for a week's time, my lord, I will make sure that some
compliance is.
It is already 1 year, 3 months is over, my lord. The honorable court has passed the order on 2023, 23rd May 2023. The last time also the same submission he has submitted.
Last order on
16,
Also they have
86, my lord.
Undertaken to file the affidavit before this honorable court.
Because for a week's Monday, my lord, I will make sure file some. Lord, I've also attached the sketch, my lord, which has already been prepared. We have tried our best to allot him an alternative site, my lord, but due to, Lord, if he's.
Actually, my site was taken by them in the year 1992. 40 years over, they have acquired my site, private site, to construct a wall to the river.
What is this? Some site is to be allowed.
Yeah, site.
Alternative site had to be allotted.
1992.
I've already filed an affidavit, my lord. I've already recognized an alternative site and I've showed it to him, my lord. But there are objections from the public to hand over the site to him, my lord. That is why I had made an affidavit stating that I will search another alternative site and hand over the alternative site. For that reason, my lord, I'm seeking a week's time, my lord. On 16/6, my lord, is an order of this court.
45 days. 18/6/24.
So what happened to earlier grant?
1 year and 3 months.
Lord, that-
Single.
By deed dated 19/6/2006.
No, my lord, 23rd May 2023, the single judge passed this honorable order.
That, my lord, my request, my lord.
Earlier property was granted to you
Yes.
under registered sale deed dated 19/6/2006. What happened to that?
No, that also they have not given.
Why
There is
not
some
given?
problem. They are not given. They have not registered the site.
Not registered.
Not registered. Still they are postponing things.
Lorna Singhal stated that which was
Within
earlier
3 months.
granted by BBMP under a registered sale deed. It is not
They have
registered.
not made.
So you do whatever you want to do, but comply with the deed.
I will, my lord. By Monday, my lord, I'll make sure that.
Monday.
Much obliged.
While order was passed on 18/6/2024, reading as under, quote the order and continue. Learned advocate for the BBMP prays for time until Monday, 10 over to 13th of.
Much obliged.
Much obliged.
Number 29.
For petitioner.
Accusement.
For petitioner.
Accused, my lord.
Order has not been complied with.
Lord, in this case, my lord, I undertake to file a wakalat on behalf of the accused, my lord. What happened, my lord, earlier our officer has been transferred to the other, my lord. Now, my lord, they made, my lord, to correction, they now who are the officer of the court, officer of the, my lord, the respondent party.
2nd September. By that time you.
My lord,
whatever you-
week's time, my lord, the counterfeit is ready, my lord, but my lord, I had impediment to file a affidavit because my lord, earlier officer is not there, my lord. That is the reason, my lord, they, my lord, made a correction on the officer, my lord, I will fight.
Let them.
Let my learned friend appear, but it appears they are not going to implement the order.
No, my lord. In fact, my lord, what happened, my lord, this honorable court has been directed to the petitioner to, my lord, he has given undertaken before the honorable court. They say that, my lord, modified plan will be submitted. They are not submitted the modified plan. Kindly see, my lord, impugned order. Impugned order, my lord, may I read? Point number 3, my lord. The petitioner having undertaken to submit the plan for approval over the remaining portion of the land, leaving out of the area earmarked for the expansion of the road. Point number 3, my lord. The order passed by this honorable court.
Married. The plan is not submitted, my lord. Afterwards, we will consider that one. The petitioner having undertaken to submit the plan for approval over the remaining portion.
All the documents required by them have been submitted.
No,
My representation says so at page number 28. In any case,
Plan is submitted.
No.
You find out by the time.
I'll find out very well.
The representation is given, my lord. Plan is not sanctioned because, my lord, as per the master plan, it is reserved for the road, my lord.
His government says that plan is submitted.
I mean, that is the reason, my lord, counter is ready, my lord. I will want to file. Let them, my lord, Medcom.
December 30. Sherville,
My lord, appealing for the complaint is matter, my lord. My lords, a review petition has been filed, my lords, this effect, and it's set to be listed tomorrow, my lord.
Review petition has been filed before the single judge, my lord. It's been listed tomorrow, my lord. May I request for 2 weeks, my lord? Once the review petition has been heard, my lord, I will. Tomorrow it's been listed.
30th August.
Yes.
Obliged.
Much, much.
For 31. The AV Nishan.
You're submitting for the respondent accused. Filed, you have passed an order, my lord. Accused have already passed an order. My memo is ready along with it.
My lords, they have partially complied with the, they have only partially complied with the settlements.
We file with the.
Complied with.
Yes, my lord,
Partially
file.
complied, sir.
Partially means.
No, they haven't completely complied according to the judgment order of the writ petition, my lords. If you can come to page number 14, paragraph number 10, the benefits that the petitioner is entitled to, including any terminal benefits if withheld and not so far, the same shall be made over to the petitioner within a period of 2 months, and the date of the receipt of the copy of the order is served to the court. And if you come to page number 16, that is the total amount is there, and the compliance of the order is like partial. They have given in total like of the compliance of the memo that is in page number.
So.
A total of 12,22,776 rupees. And another check of 3,49,239 rupees.
So amount is also remitted.
Yes, my lords, 12 lakh something has been remitted, my lords. Pensionary benefits.
What is the difficulty now?
So they have not completely complied with the order, sir.
What is the difficulty? No difficulty. Disposed of, we'll dispose.
Sir, no, sir. if this court may seek to pass an order, liberty may be given to us to challenge this order.
For what purpose you want to challenge? Tell us. Sake of giving liberty will not give, for the sake of,
Liberty may be granted, sir.
in this contempt proceedings, in this contempt petition. Judgment and order dated 18th December 23 of Lorna Single Judge was brought under scanner for its non-compliance. The disciplinary proceedings initiated against the petitioner were held to be barred by limitation in view of Rule 214 into 2 into small b into bracket Roman 2 of the rules. Further statutory the court directed paragraph that the petitioner shall be entitled to terminal benefits, including terminal benefits, to be paid within 2 months. In response to the contempt petition from a learned advocate, Ms. So-and-so appeared and filed her memo dated 8/5/8/24. Also, along with the memo, produced is the copy of.
My lord's order is passed on 8/7/2024.
Order dated 8/7/24, claiming that the order is complied with. Also produced the remittance slip of ₹4. $1,22,776. Towards the sum payable to the petitioner. Copy of drawn on Union Bank of India, dated 16/7/24 is produced. The amount is transferred from one bank to another bank in different names towards the payment. The court finds that there is a substantial compliance, to say the least, of the directions of learner single judge. Contempt proceedings are not liable to continue. They are disposed of if any grievance paragraph persists for the petitioner with regard to the amount paid, petitioner is not precluded from initiating independent proceedings with regard to any grievance which the petitioner may have. In this paragraph, this court does not express any opinion on the merits of such claim or recourse. Full stop. Contempt petitions are disposed of as not surviving.
Should be very quick. They will. Serial number 36, my lord, and for the complainant, the order has been complied by the respondent.
36, 36.
36.
Compliance affidavit.
Start filing the affidavit. It's complied.
Who is filing?
Lots.
And additional government advocate Ms. Pramodini Kishan files compliance affidavit dated 5/8/24. The contents thereof suggest that the directions of law on a single judge in writ petition number 10701 of 24 asked by law on a single judge has been complied with. Paragraph, when copy of the compliance affidavit was given from a learned advocate Ms. So and so appearing for learned advocate Mr. Naga Rajappa for the complainant could not dispute the factum that the order of law on a single judge has been complied with. In that view, nothing survives in the contempt proceedings, nothing survives in the present contempt proceedings, they are disposed of accordingly.
Obliged.
List one, serial number one, it's a pass over matter.
I'm appearing for the complaint in this case, my lord.
Pataviram.
For complying officer, in 2 weeks' time, maybe give.
2 weeks' time.
Yes, my lord.
At the request of learned advocate for the complainant, stand over to 6 September.
What's your please?
List number two, serial number three.
Review of the state.
In respondent number 4, the ASG want to appear in this case, my lord, but he is not available today.
Okay, this, so this 10716 and both are different.
They are different. They are different.
So what about this serial number 3?
Yeah, yes, that's the one in which I have completed my arguments. It is to do what to today because the learned government advocate said they will make their submissions as well as the learned counsel for KEA. But before that, my lords had asked for the citation of that Anushka judgment. I have got the reported judgment of
AIR.
It is
AIR.
reported in AR 2023, Supreme Court 903.
Now, what is this petition?
This petition, my lord, lords may recall, petitioner is seeking for the general seats in the Hyderabad, Karnataka category. She, my lord, has
In this 10716.
no, not in that, my lord. In
So we are-
10716,
We are having 1071.
10716, she is only seeking to be considered, the petitioner, he is only seeking to be considered on par with Indian citizens because he is an OCI card holder from Karnataka, from Bangalore. So that, my lord, there, I think they are conceding that they are not disputing that he is.
We have given them out. We have given them this status. We have asked them to register. We are counseling them on. It's squarely covered by, my lord, unless, my lord, they are claiming any reservation. If they are not claiming reservation. it will be
10-0,
recorded
10, I am not claiming. I want to be considered on par with the Indian citizens, that is all.
in the general category there also. I am not claiming any Hyderabad, Karnataka or any such subcategory. Lordship may kindly see the prayers, my lord, in that 10716. One prayer, my lord, will explain everything. Second one, my lord. Prayer B at page 21. May I read, my lord? Issue a writ of mandamus or any other appropriate writ, order or direction directing respondents 1 and 2 to permit the petitioner to participate in the online counseling for CET 2024 to be conducted by the second respondent as per notification number so and so, issued by the second respondent NXG, and permit him to participate in the counseling for CET 2024 for engineering technology seats, so and so, etc. seats for the academic year 24-25 for admission to the undergraduate engineering courses in Karnataka, and allow him to choose the set seats on the basis of his merit and ranking in CET 2024. This is as far as the engineering is concerned. Next one. Issue a writ of mandamus or any of the appropriate writ, order or direction directing the respondents 1 and 2 private petitioner in the online counseling process. Same. That is in the private colleges. The first one is in the government colleges. In fact, I am told they are allowing even for medicine also. Even there, they are permitting.
Here also Anushka will apply.
Applies, squarely applies according to.
Right to applies. The right of that not to be disputed.
This petition came to be filed by the petitioner student. Aspiring to be considered for admission to the medical and engineering course.
Medical and engineering.
For the academic year 2024-25. The principal grievance and prayer of the petitioner was to direct Response number 1, State of Karnataka, and Response 2, as Karnataka Examination Authority, to permit him to participate in the online counseling for CET test 2024, which was conducted by the Karnataka Examination Authority into KEA as per notification dated 9/1/24. The petitioner paragraph happens to be an overseas citizen of India, into bracket OCI bracket over, card holder, who has been studying in Karnataka for last 8 years, for the past 8 years. He has completed 10th standard examination from Bengaluru and will be appearing in the 12th standard examination.
He has appeared and passed also. That was when I filed the petition, he was.
And he has also appeared and passed the 12th standard examination. The apprehension paragraph of the petitioner, who is OCI card holder registered as such under section 7 capital A of the Citizenship Act, was that since he was OCI, he would not be considered by the authorities for the purpose of allowing him the participation in the election process along with Indian citizens in general category. Full stop. In support of the claim in the case, the petitioner relied on the decision of the Supreme Court in Anushka Guthwar versus Union of India. Gunthwar versus Union of India, AIR into bracket 2023 Supreme Court 903. Paragraph. It is to be noted that interim order was passed.
Yes, yes.
There is that interim order. It is called past interim order. Dated so and so, so and so. 28/6/24. Permitting the petitioner to participate in the online counseling for admission to the undergraduate courses in medical, dental and engineering for the academic year 2024-25 for both government and private seats, treating the petitioner at par with Indian citizens. Paragraph. When the petition came for consideration today, learned advocate Mr. N.K. Ramesh appearing for the KEA, as well as learned additional government advocate Mr. Sudev Hegde stated that the petitioner, who is an OCI citizen, shall be treated along with the citizens for the purpose of considering his claim on merits in general category in undergraduate courses in medical, dental and engineering for the academic year 2024-25. And the admission, if available on merit, shall be given to the petitioner in general category. Full stop. In view of the above statement, learned advocate Mr. So and so for the petitioner would fairly submitted that the grievance of the petitioner does not survive and the petition may be disposed of accordingly. Full stop. Record in view of the above statement, the prayers and the petition stand satisfied. The petition is disposed of accordingly.
Like.
Sure. What about?
Number 4.
Please, my lord. This case, my lord, I am going one step ahead.
4 is to be heard, same.
In addition to being treated along with Indian citizens for counseling in the general category, here I am seeking for a specific direction that I should be treated along with the citizens in the general category for the Hyderabad, Karnataka general category seats.
Now let us see how you can rely on this, Anushka.
Please, my lord.
How do you rely on this?
Yes.
From which paragraphs and which observations?
Yes, ma'am. May I refer to the reported judgment or to the writ petition where I have produced the copy, my lords? Reported judgment.
Whatever, wherever.
Please, ma'am. Yeah. May I just clarify two aspects before I read the relevant paragraphs, my lord?
Now this category of Hyderabad, Karnataka is carved out under what provision?
Under the Hyderabad, Karnataka presidential order issued by the government of India.
That is under 371J.
Under 371J. I have given a copy of that, my lord. It is the Karnataka Educational Institutions Regulation of Admission in the Hyderabad, Karnataka region order. Clauses 6 and 7 provide for reservation in regional and educational institutions situated in the Hyderabad, Karnataka area. Clause 6. So,
Clause 6.
Clause 6. Clause 6.
Reservation.
My lord. Reservation in regional universities and educational institution, admission to 70% of the available seats in every course of study in any regional university or educational institution referred to in the first schedule in the local area shall be reserved in favor of the local persons in respect of such university or educational institution. Kindly turn to the first schedule. A, first schedule. All courses up to and inclusive of the postgraduate level provided by the educational institutions affiliated to the university established by law in respect of a private educational institution in respect of seats given to government for allocation in other universities in the region, namely Krishna Devaraya University, Ballari, Gulbarga University, any other university including deemed university will be created subsequently in government sector, PPP, any other model. So in these universities and educational institutions.
So the elite category under this order is the domicile.
Government.
Domicile of Karnataka. Under section 4 of the order, section or regulation, whatever.
Yes. Order, presidential order.
So this is reservation for
local persons.
Local
persons. The order itself does not make any further.
Local persons who fall within the purview of section 4.
Clause 4, yes, section 4 or clause 4.
Clause 4.
You could belong to any caste, any community.
So do you satisfy this?
Yes, I satisfy this. I satisfy this.
Under which clause you are falling?
Clause 4, domicile, clause 3.
Clause 4,
clause 3. Apart from the fact that I have myself studied, this is squarely covered. Where either of his parents has studied in an educational institution in such local area for a period of 10 consecutive academic years. My father and mother both have studied. 4.3. Next is clause 7, which may be more applicable to me because I am a medical aspirant. Clause 7. Reservation, may I read, my lord? Clause 7. Reservation in statewide universities and statewide educational institutions.
Which we are reading what?
Clause 7 of the order, presidential order. Clause 7. I read clause 6, which provided for 70%. I am reading clause 7 now. Reservation in statewide universities and statewide educational institutions. 8% of the available seats in every course of study provided in a statewide university or a statewide educational institutions referred to in the second schedule be allotted among the local candidates of the Hyderabad, Karnataka region. While determining under subparagraph 1 the number of seats to be reserved in favor of the local persons, any fraction of a seat shall be counted as 1. So when it comes to that particular local area, here, my lord, if I may just even name the districts. The Vijayanagar district, Ballari district, Koppala, Raichur, Yadgir, Kalaburgi, and Bidar. These are the 7 districts which constituted the local area of Hyderabad, Karnataka. There, in any educational institution situated there, 70%. 7-0. But if the institution is situated outside of these areas, in any of the Bombay, Karnataka region, as it is known now, earlier, or the coastal area, or the old Mysore area, my lord, it is 8%. Second schedule may kindly be seen at the next, after the one is statewide universities, University of Agricultural Sciences, Bangalore, University of Agricultural Sciences, Dharwad. 3 is relevant because I'm a medical aspirant. Rajiv Gandhi University of Health Sciences, Bangalore. So this is a statewide university. So Rajiv Gandhi University of Health Sciences. So here, my lord, if the college, medical college is situated in, say, Kalaburgi or Bidar, which is affiliated to Rajiv Gandhi University of Health Sciences, then because it is situated in the local area, 70% of the seats in that particular college, 7-0. But if the medical college or institution is situated outside of that local area, supposing it is situated in Bangalore, Chikballapur, Kolar, Mysore, Tumkur, Shivamogga, or any of these areas which are outside of the Hyderabad, Karnataka area, then the reservation is only to the extent of 8%. In these, my lord, while issuing the seat matrix, what the KE has done with the approval of the government is they have further, Hyderabad, Karnataka seats, total seats are calculated. Up to 50% of those total seats are general seats. The remaining 50% is what is provided for as reservation for the under Article 15(4) for the scheduled caste, scheduled tribes, OBCs, category A, B, C, D. So my prayer is that in that 50% of the Hyderabad, Karnataka general seats, I should be considered. Because Indian citizens in the general category are being given those seats. When it is, once it is considered that an OCI card holder can be considered for the general seats, the only issue for my lord's consideration, wait.
This Hyderabad Karnataka quota is general seat?
There are general, there are reserve, both.
It is both?
Both.
In this Hyderabad Karnataka quota?
Yes.
There are general seat as well as reserved seat?
Yes. Yes.
So within that also reservation is there?
Within that also there is a sub-reservation.
Scheduled caste, scheduled tribe?
Yes.
Even
yes.
in this?
Yes. Yes.
You want consideration in the segment of the general category?
Precisely.
In
Yes.
Hyderabad Karnataka?
Yes, precisely. There is both vertical as well as horizontal reservation within the Hyderabad Karnataka category. That's why I had given the seat matrix, my lord, on the last occasion. If it is available in the file, my lord, the seat matrix, that was for the academic year 23-24. This year, the seat matrix has not yet been issued. Therefore, I am not in a position to produce it. But the previous year's seat matrix, according to me, my lord, unless the intake is increased, it will prevail. There in Bangalore, I gave the example of Bangalore, my lord. 16 seats are reserved for persons from the Hyderabad, Karnataka area. totally 16 seats. Out of which 7 seats, 16, 16 seats for Hyderabad, Karnataka,
Yes.
in Bangalore Medical College. This constitutes 8% of the seats as per the presidential order.
16 seat in Rajiv Gandhi.
Since it is Rajiv Gandhi, yes, it is Rajiv Gandhi. Out of these 16 seats, 7 seats are reserved for Hyderabad, Karnataka General. The remaining 9 seats are the reserved seats. Reservation for SCs, STs, OBCs and others. I am not staking a claim for those 9 seats at all. I am staking a claim for these 7 seats. I had also read out, my lord, there is a Gulbarga Institute of Medical Sciences which is situated in Kalaburi. There the extent of reservation for Hyderabad, Karnataka, let me call it, my lord, as not more reservation, it is like they have earmarked certain seats for people from the local area. Out of that, 70% there works out to 38 seats. So 38 seats in Gulbarga Institute of Medical Sciences is reserved for Hyderabad, Karnataka, out of which 19 are meant for general category, 50%. The remaining 19 are the reserved seats. Similarly with Bidar.
So let us see this, Anushka.
Anush, please. May I just once or two sentences, my lord, before we proceed to Anushka. As far as these OCA card holders are concerned, my lord, they were all governed by a notification of the year 2009, 5th January 2009, where their rights were all defined. Thereafter, my lord, the notification, one more notification was issued on the 4th of March 2021. That codified all the rights of the OCA card holders and said you are eligible only for NRI seats. So from 2009 to 2021, there was one particular law which made us eligible for all seats available to Indian citizens. But from 21 onwards, the central government said you are eligible only for the NRIs. They further clarified by means of an explanation that OCA card holders will be treated as foreign nationals, one, and an explanation which stated that they shall not be considered for any seats reserved for Indian citizens, exclusively reserved for Indian citizens. That notification came to be challenged in Anushka's case. So there, my lord, in paragraph 19, my lords may kindly turn to now Anushka. Paragraph 19, my lord gets it at page. Supreme Court, page 11 of that cited judgment, which I am. Paragraph 19. This states what the law was earlier. Through the said note, my lord gets it, my lord, paragraph. Through the said notification dated 5/1/2009, the OCA cardholders were given the right to pursue the professions indicated therein in India and also to appear for the All India pre-medical test or such other tests to make them eligible for admission in pursuance of the provisions contained in the relevant acts. Since NRIs had parity with the Indian citizens in that regard, the same benefit became extended to the OCI cardholders, including the petitioners herein. So this was the law prior to 2021. We were given parity with the Indian citizen.
Prior to 2021.
4/3/2021.
What is that 4/3/2021?
That is when the fresh notification was issued by the central government.
So this NRIs NRIs obviously can't come in this Hyderabad.
NRIs were considered as Indian citizens. They had that benefit. NRIs are essentially Indian citizens.
So do
Only
they-
for the purpose of domicile or for tax purpose.
So because of domicile, they go out of this.
Yes.
Otherwise, if your content, your argument is taken to logical end, NRI, but for the domicile qualification, would fall under this Hyderabad court.
My lords. NRI, my lord, there is a separate category. They will go under that. First aspect. But in addition, if an NRI further fulfills the domicile requirement of being in Hyderabad, Karnataka area, being an Indian citizen.
So since NRI had the parity with Indian citizens, this OCI are given parity with Indian.
With Indian citizen. Yes, that was.
OCAs are given a benefit more than what the NRI is getting,
More than,
what the NRIs are getting.
correct.
So, in fact, at that point of time, the definition, if it is seen, my lord, NRI must essentially have studied his 10th or 12th standard outside of India. Only then he qualifies to be an NRI. Now, I am an NRI. I go and work elsewhere, but my family remains here, either in Bangalore.
NRIs are not citizens of it.
They are citizens.
No.
Right.
They have a they have a different channel altogether for NRI.
They are citizens.
No, they are not citizens.
They're not, NRIs are not citizens, only they do.
No, they are citizens. I totally disagree.
NRIs are in this.
So
I'm sorry, I'm
neither
sorry.
Neither NRI is a citizen, nor you are citizen.
NRI is citizen. My lord,
We are testing by a process of logic there. Therefore, this is the elementary questions. Neither NRIs are citizens, nor OCIs are citizens. Correct?
Second part, the
Correct.
latter part, my lord, I agree. We are not citizens. But I, my lord, would like to emphasize again that NRI are citizens. They may not be staying here. They hold Indian passport. They hold Indian passport. They are citizens of India. They might have gone abroad to work.
All right, chalo. Then proceed. Yes, then.
So,
But
they hold the Indian passport. That is the most important.
but you are in any case not citizens.
No, OCI is not. I hold a foreign passport. I hold a foreign passport. I am here in this case. He's a UK citizen. And I hold a passport issued by the United Kingdom. But all NRIs hold Indian passports. And they may be resident abroad. That is the concept, my lord Justice Arvind will be aware about it under the Income Tax Act, because this is if you are resident of India beyond 180 days, outside of India, an Indian citizen who is residing outside of India for a period of 180 days or more will be called as an NRI. He doesn't lose his citizenship. May I just illustrate it with an example for NRIs only. Now, I am an NRI. I am working, let us say, in the Gulf country, where the payment or the salary is much higher. But my wife and children are resident here in Bangalore. Now, being an NRI, your lordship will have to appreciate this aspect of the matter. We are dealing with the educational rights of children. I am an NRI. I am staying there for the past 5 years. I have not relinquished Indian citizenship. I'm going there only because I have got a visa or a work permit in the Gulf country. I'm getting a handsome salary there. I come back every year or maybe once in 6 months, I come to Bangalore, stay with my family. But my wife and my daughter are studying here in Bangalore. Now, my daughter
This OCI is a
yes, under the Citizenship Act. Section 7A, that is all extracted in the judgment of Anushka. The provisions, any person who is registered under Section 7A of the Citizenship Act is called as an OCI cardholder. That is the definition under Section 7A. Kindly turn to paragraph 14 of the Anushka's judgment. In that regard, the provisions of Act 1955 which are to be noted, read as hereunder. Section 7A, registration of overseas citizen of India cardholder. The central government may, subject to such conditions, restrictions and manner as may be prescribed on an application made in this behalf, register as an overseas citizen of India cardholder any person of full age and capacity who is citizen of another country but was a citizen of India at the time of, any time after the commencement of the Constitution, or who is a citizen of another country but was eligible to become citizen of India at the time of the commencement of the Constitution, or who is citizen of another country but belonged to a territory that became part of India after the 15th day of August 1947, or who is a child or a grandchild or a great grandchild of such citizen, or a person who is a minor child of a person mentioned in clause A. A person who is a minor child and whose both parents are citizens of India, or one of the parents is a citizen of India, or spouse of foreign origin of citizen of India, or spouse of foreign origin of an overseas citizen of India cardholder registered under Section 7 ND, and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application under this section. We will come only under this clause 1 because both our parents, my parents, both my parents were citizens of India before they went abroad. My father took UK citizenship. My mother also followed suit. I was born there, therefore I have become a UK citizen. So, in the present case, clause 1 will apply. A1. I am a minor child. When I was registered, my lord, I was a minor child of a person who was a citizen of India. Annexure A is my OCI card, which has been issued by the government of India. Annexure A. So those factual aspects, there is no dispute according to me. They admit that I am a citizen of India, overseas citizen of India. I concede that I am an OCI card holder. In the same paragraph, my lord, the rights of the OCI card holders are stated. The list, my lord, is what can be called as a negative list. These are the lists that these are the rights that you can never be granted. Government cannot grant. The statute itself prohibits these rights. Other than these, I am entitled to anything which the central government may confer. So this is basically a conferred right. What are these rights which are prohibited to me? Becoming the President of India, Vice President of India, a member of Parliament, a judge of the Supreme Court or of the High Court.
Which
or
one?
7B.
Wow, you're reading.
Paragraph 14 of Anushka's judgment.
14.
Yes.
14.
there. After 7A, my lord gets 7B, section 7B, capital B.
Paragraph 14 on which page?
Page is page 9 of the page nation is at the right hand bottom side, page 9.
Paragraph 14, yes.
Yes. Conferment of rights on overseas citizen of India card holder. My lord gets it, my lord. 7B, capital 7B. 7 capital B, rather. Next page on the right hand.
In this regard,
Uh,
that is how it starts. Paragraph 14 starts like that.
What was that? The next page, my lord, is 7B.
Yes.
Next page is 7B. Conferment of rights on overseas citizen of India card holder, notwithstanding anything contained in any other law. It becomes begins with the non-obstante clause. Notwithstanding anything contained in any other
It's
law.
7B of what? Citizenship Act?
Yes,
7B
of the Citizenship Act. 7 capital B of the Citizenship Act. Conferment of rights on overseas citizen of India card holder, notwithstanding anything contained in any other law for the time being in force, an overseas citizen of India card holder shall be entitled to such rights other than the rights specified under subsection 2
But then
as
the whole point is that 371J itself is a reserved category.
my lords.
371J
Yes,
itself is a reserved category.
my respectful submission. Of course, I would call it as regional representation. Because if it is reservation in the strict sense of the word, as has been used all these days, yes, my lord, it would mean that for certain oppressed communities or backward communities, socially and economically disadvantaged class of citizens, that would be called as reservation. That is how it is understood.
So it's
from-
this, according to it, is special treatment, not reservation.
It is a representation, special treatment.
Special treatment.
Special treatment, yes. And there, my lord, it does not distinguish between persons who belong to the scheduled caste or the scheduled tribes or OBCs or general category. Anybody who is living in that area, who has studied in that area, who is a domicile of that area, who is a local person, anybody is entitled to that Hyderabad, Karnataka representation. Special provision, 371J. In fact, the constitution itself, the heading is special provisions. All scheduled tribe areas, wherever there is backwardness, there is no economic development. How do the people from that area come up? So let us give them some representation. Now, while giving that representation, the state government has subclassified their reserved category and general. So, as I said on the previous occasion, my lord, a person who belongs to the upper caste or from the higher strata of society living in Bangalore, he will not get this Hyderabad, Karnataka benefit. But the same person, upper caste person, who is living either in Gulbarga, Bidar, Raichur, Kopla or any other place, notwithstanding the fact that he belongs to the upper caste, he will get this representation. So it defies logic to call these general seats a reserved seats. And if all the seats had been thrown open, it might have led to further challenge from the scheduled caste and the scheduled tribe saying that there is no reservation. So we are unequals, we are competing. Therefore, my lord, state government has said, let us further subdivide 50% of the seats for the general category. Whoever is there from that local area, 50% for the reserved category within Hyderabad, Karnataka. A scheduled caste person, again, a scheduled caste person who is at a high disadvantage staying in Bangalore will not get a scheduled caste seat reserved for Hyderabad, Karnataka. He suffers a much more greater disadvantage than a scheduled caste person from the other areas. That is the underlying policy, philosophy. Give it to anybody from that area. Kindly see Article 371J. It doesn't use the word. It says special category. Special provisions, in fact, there are special provisions with respect to state of Maharashtra and Gujarat, 371. 371A with respect to Nagaland. 371C is with respect to Manipur. 371D is special provisions with respect to the state of Andhra Pradesh and the state of Telangana. Now coming to 371J. Even in the legislature and other places. G is with reference to Mizoram. H is with reference to Arunachal Pradesh. J, the heading given. Constitution of India, Article 371J. Special provisions with respect to state of Karnataka. The president may by order with respect to the state of Karnataka provide for any special responsibility of the governor for establishment of a separate development board for Hyderabad, Karnataka region with the provision that a report on the working, this is as far as the economic progress is concerned, developmental activities is concerned. B is equitable allocation of funds for developmental expenditure over the said region, subject to the requirements of the state. Now, all development activities will be concentrated here in Bangalore, Mysore, Tumkur, Kolar. So no funds are allocated. So 371J says it is not just for reservation, it is for overall economic development. Developmental funds, allocated funds. The C is what is real. Equitable opportunities and facilities for the people belonging to the said region. No distinction is made with reference to any caste, community, class, category. To the people belonging to the said region in matters of public.
Where you are reading?
Article 371J, Constitution of India.
For the people, where is for the people?
Equitable opportunities, that is clause C. Equitable opportunities and facilities for the people belonging to the said region in matters of public employment, education, and vocational training, subject to the requirements of the state as a whole. So this is the special responsibility of the governor. And the order is made by the president. So a person from Hyderabad, Karnataka area gets an equitable opportunity, employment. Now, in view of the fact that this regional representation is what is emphasized upon, it may, as my lords have observed, it may be called as a reservation also. But according to me, only those seats which are given for the backward classes within Hyderabad, Karnataka will fall under the definition of reservation strict sense. The general seats will not fall under that category. It is not enough if I fulfill just that category. I must fulfill the condition of being a local person. If I fulfill that condition of being a local person, how can it be denied to me a general seat? Now, it was open to my father, being a doctor, to come and have settled down in Bangalore, worked in a private hospital, start his own clinic. He chose to settle down in Ballari. Not only did he choose to settle down, he said, my wife and daughter will follow me. And I have also studied in Ballari. If I was here in Bangalore, I would not have claimed it at all. I could not have claimed it because I don't fulfill the domicile requirement. Now, if I fulfill, two conditions have to be fulfilled, my lord, here to be considered. First is citizenship. I fall at the very first hurdle. I fail there. I am not a citizen. Supreme Court comes to my rescue and says, no, don't insist on the first condition of being a citizen. OCI, treat them along with Indian citizens or parity with Indian citizens. So I need not fulfill this first condition of being a citizen. There is a second condition. If it were to be then an OCI sitting in UK or sitting in USA can claim this. That is where the second rigor comes into force. You should have not only be a overseas card, you should have come back to India. You should have stayed in that area for 10 years, or your father should have stayed there for 10 years. So I satisfy both these. I don't satisfy the citizenship in the strict sense of the word, but because of the Supreme Court judgment, they cannot insist on this condition. And in the matter that my lords have just disposed of, the previous matter, 10,716, they are themselves conceding that they are not insisting on this aspect of citizenship at all. They are being considered on par with Indian citizens. 10,716, which my lords just disposed of. That is the statement which is being made at the bar. When once they say citizenship cannot be insisted upon, then they have to automatically then fall and see whether I fulfill the second condition. If I fulfill the second condition, then they have to consider me under the Hyderabad, Karnataka generals. That is my case. The first case, my lord, covers, the previous case covers 90% of the law. How are OCA cardholders to be considered or treated? They have to be treated as Indians.
So you're not coming in general category,
I am coming in general category. I am actually.
but for your claim in Karnataka, Hyderabad,
Yes.
you are not qualifying.
Actually, my father belongs to OBC, but I am not claiming it.
No. What we are asking is different. Unless you claim in Hyderabad, Karnataka category.
Yes.
In general. Okay.
Yes.
You are not getting on merit in the other general category.
I may get, I may not. I am contesting there also. In the general category, all over the state, in the other general seats. I am claiming there also. That is, they will consider it automatically. The first aspect, as my lords observed, that I need not come to court at all. May I just read paragraph 22 of Anushka? We should settle everything. Paragraph 22 of Anushka, which is at page 13, 1-3 of that judgment. This gives absolute clarity, according to me, as to what we were entitled to and what the Supreme Court had in mind when they said, follow what was there prior to 4/3/2021. Paragraph 22 at page 13, 1-3. Para 22. It begins with the words, a perusal of the notification dated 4/3/2021. Of the notification dated 4/3/2021 would ex facie indicate that the rights bestowed on thereunder on the OCA cardholders are in fact a consolidation of the rights which had been bestowed through the notification dated 11/4/2005, 5/1/2007, and 5/1/2009. However, the impugned portion of the notification is the portion which has been emphasized, that is the proviso to clause 4.2 and explanation 1 thereto, and limiting the parity only to NRI seats and supernumerary seats. Through the impugned portion of the notification, the parity which existed with non-resident Indians, including in the field of education, has been modified to indicate their eligibility for admission only against non-resident Indian seat or any supernumerary seat. It is relevant to take note herein that the non-resident Indians, apart from the seats reserved only for non-residents, are also entitled to participate in the selection process for allowed seats, along with Indian citizens for the remaining seats as well. So NRIs could compete, my lord, both in the NRI seats as well as the citizen seats. Further, my lord, for the remaining seats as well, which benefit was hitherto available to OCI cardholders by virtue of their parity with NRIs. However, by presently specifying that the OCI cardholders would be eligible for only the non-resident Indian seat or any supernumerary seat, the right available to the OCI cardholders is only for the seats which are reserved as NRI quota seats, for which they would have to compete with the NRI candidates for the limited number of seats, for which higher fee structure is also fixed. The proviso thereto makes it clear that the OCI cardholders shall not be eligible for admission against any seat reserved exclusively for Indian citizens. The provision contained in the impugned portion of notification date 4/3/2021 would indicate that the OCI cardholders, my emphasis would be on this underlining, my lord, even if they have settled down in India and have undergone their entire educational course in India, but not having renounced the citizenship of a foreign country and not having acquired the citizenship of India, will now be denied the opportunity of securing a medical seat in the general pool of Indian citizens, including NRIs, and will have to compete only for the limited seats available under the NRI quota, which would be a denial of an opportunity of education to such OCI cardholders, which was hitherto available. So, whatever has been stated here squarely applies to me. On all fours. Denial of opportunity, Article 14, which is available to everybody, irrespective of citizenship. Now, in all these cases, what was tested was whether you can be treated on par with Indian citizens or along with citizens. There was no doubt at all. They are even conceding. In Karnataka, because of the special provision of 371J, whether I am entitled to that Hyderabad, Karnataka general pool of seats is what is being contested. That is what my lords are called upon to decide. If my lords hold that the general category seats are open to me, they will have to consider me as in the general pool of Hyderabad, Karnataka. If my lords hold that is also a reserved seat, then that becomes, my lord, prohibited for me or not available to me. That is all my case. I have produced so many documents, my lord. These are for them to verify. I do not want to trouble my lords going through those documents, and many of those documents are in Kannada. They have what is known as a document verification process. When I appeared for the document verification, I had claimed Hyderabad, Karnataka in my application. I said, I want to be considered in my online application, which I had submitted to KE. There they said, Hyderabad, Karnataka, during document verification, which just took place about 15 days ago, they entered no. That is all, my.
There is no dispute that the petitioner is not a citizen of India. Secondly, my lord, I don't think there is a dispute that they are claiming any reservation. But here I would. Please.
It contains a category of citizens and general. They must have enrolled in it because they possess the same legal characteristics. of general category and equation receiving. And they are seeking support from three. Namely, that they become domicile person because of the father, the mother, studied for 10 years, 8 years.
15 years.
15
15 years, 1 5.
So they have to get out from there. These are the they belong to the same common class. The characteristic of the class as that of citizen, either viewed independently or in the context of Karnataka. You answer.
Now, my lord, may I produce, my lord, the bill, 118th Amendment Bill, to know the statement and objects for which the Article 371J was filed. I filed my reply, my lord, but these are independent. It's not there on the file. Replace the file. Let me. Not trouble, my lord, I will not read the entire portion. I'll persuade my lord to kindly come to the preface. Preface is, I'm sorry, my lord, I'm not paginated. About 7 pages in, there's a preface. Starts from what? Lord, the bill which I just produced. This gives us clarity, my lord, as to why 371J was required to be passed at that point of time. The preface, in para number 3, it says, the bill seeks to insert a new article 371J in the Constitution of India to provide a special provision introduction of 371J. Please, the preface one. The bill seeks to insert a new Article 371J in the Constitution of India to provide a special provision to establish a separate development board for the erstwhile Hyderabad Karnataka region of the state of Karnataka, consisting of the districts of Gulbarga, Bidar, Raichur, Koppal, Yadgir, and Bellary, to accelerate development, promote inclusive growth, and provide for reservation in education and vocational training institution for domiciles of the region. In fact, my lord, the very object says that it's to provide reservation. My lord, may kindly turn to the next page, my lord. That is the report. The first clause is the introduction clause. 1.1. The Constitution 118th Amendment Bill 2012, hereinafter called the bill, proposes to insert a new Article 371J in the Constitution to provide special provisions for hostile Hyderabad Karnataka region of the state of Karnataka, consisting of the district of so-and-so, to accelerate development of the most backward region of the state. Lord, now the second objective of the bill, clause 2. According to the statement and objects and reasons of the bill, the proposed Article 371J makes a special provisions to establish an institutional mechanism for equitable allocation of funds to meet the developmental needs over the Hyderabad Karnataka region, as well as to enhance the human resources and promote employment from the region by providing for local cadres in service and reservation in educational and vocational training institutions by an amendment of the Constitution of India. Makes it very clear, my lord, that it is a reservation for all purposes. Lord, may kindly take the next page, my lord, 2.1.1. The statement of objects and reasons of the bill further stipulates that the Article 371J in the form of a special provision seeks to provide for A, establishment of a separate development board for the aforesaid region mentioned above. B, provide for equitable allocation of funds. My lord, may take my lord to C, provide reservation and public employment through the constitution of local cadres for domicile of the region. D, provide for reservation in educational and vocational training institution for the domicile of the region. Lord, going through these objects and reasons, my lord, it is very clear that this is a reservation, my lord. In fact, even Article 371J, which was not read in its entirety, though it says special provisions with respect to the state of Karnataka, 371J subclause 2, my lord. An order made under subclause C of clause 1 may provide for reservation of a proportion of seats in educational and vocational training institutions in the Hyderabad, Karnataka region for students who belong to that region by birth or by domicile, and so on. Constitutional. 371J, subclause 2. An order made under subclause C of clause 1 may provide for a reservation of a proportion of seats in the educational and vocational training institutions in the Hyderabad, Karnataka region for students who belong to that region by birth or by domicile. In fact, my lord, you were right in holding that this is a reservation in a reservation is what they're claiming. The general, my lord, there are 100% seats. 15% is reserved for NRIs, 40% for the government, 40% for the private, and 5% for the management seats. Now, this Hyderabad Karnataka region is a quota which creates that 70% in the category, and in that there is general. That is what they are now claiming. Lord, I produced two judgments, my lord. One judgment as to why or who qualifies for this reservation. This may not be directly on the point, but this is with regard to my lord, this is 1996, 1996, 3 SEC 545. Sir, ಕೊಡ್ತೀನಿ. Balsam of them. But in this, one aspect was considered that if by marriage somebody is converted into a Dalit, will they be entitled for reservation? I take my lords to paragraph number 32, madam. Or 33, my lord, page 565. May I read, my lord? However, the question is whether a lady marrying a scheduled caste, scheduled tribe, or an OBC citizen, or one transplanted by adoption or any other voluntary act, ipso facto becomes entitled to claim reservation under Article 15(4) or 16(4), as the case may be. It is seen that Dalits and the tribes suffered social and economic disabilities recognized by Article 17 and 15(2). Consequently, they became socially, culturally, educationally backward. The OBCs also suffered social and educational backwardness. The object of reservation is to remove these handicaps, disadvantages, sufferings, and restrictions to which the members of the Dalits or the tribes or OBCs were subjected, and was sought to bring them in the mainstream of the nation's life by providing them opportunities and facilities. In Muralidhar Dayandio Kasekar versus Vishwanath Pandu Bade and R. Chandevarappa versus State of Karnataka, this court has held that economic empowerment is a fundamental right to the poor, and the state is enjoined under Articles 15(3), 46, and 39 to provide them opportunities. Thus, education, employment, and economic empowerment are some of the programs that the state has evolved, and also provided reservation in the admission into educational institutions, or in case of other economic benefits under Article 15(4) and 46, or in appointment to an office or a post under the state under Article 16(4). Therefore, when a member is transplanted into the Dalits, tribes, or OBCs, he or she must, of necessity, also have had to undergo or undergone the same handicaps, and must have been subjected to the same disabilities, disadvantages, indignities, or sufferings, so as to entitle the candidate to avail the facility of reservation. A candidate who has had an advantageous start in life, being born in a forward caste, and had the march of advantageous life, but is transplanted in backward caste by adoption or marriage or conversion, does not become eligible to the benefit of reservation either under Article 15(4) or 16(4), as the case may be. Acquisition of the status of scheduled caste, etc., by voluntary mobility into these categories would play fraud on the Constitution and would frustrate the benign constitutional policies under Article 15(4) and 16(4) of the Constitution. My lord, it is very similar to the case on hand now, because this person is a citizen of UK. She has not undergone any difficulties or the backwardness or the suffering. This reservation is provided only to lift those people who have suffered from the backwardness. Now, here is a person, my lord, who has not renounced her nationality. She continues to be a citizen of Great Britain.
Even the parents.
In fact, my lord, I think what I'm instructed is even the parents are citizens, British citizens. But now coming to the Anushka case, my lord, in the whole judgment, nowhere has it been mentioned even once. There's only one mention, in fact, of reservation. The whole 2021 notification is held to be prospective and not retrospective. So these persons, OCIs, they go back and fall on the 2009 notification. In 2009, if they were given parity along with the general Indian citizens, well, there is no mention of reservation. In fact, even before that, all the NRIs were never given any reservations up till 2009, and even now. Lord, may also kindly see, my lord, Karnataka Education Institution Regulation of Admission in the Hyderabad, Karnataka region, what my learned friend was relying upon. Lord has it.
Statement.
My lord, the order, Rule 6, what my learned friend has produced. Clause 6 also mentions that it is a reservation, my lord. Reservation in regional universities and educational institutions. 7 also mentions that it's reservation in statewide universities. If I may say so, my lord, my learned friend will be entitled only to clause 8 if there are any seats remaining. After 2 rounds of counseling, my lord, the seats automatically go to the mop-up round if any are remaining, and then they're decategorized, maybe then they're entitled. I've concluded. But I've just concluded as to what Anushka Rangatur judgment also has said. In fact, my submissions are that they will not be entitled to any reservation as such. They will be entitled to general category seats, yes, but not a reservation under reservation. Please, ma'am. No, the objects and reasons itself states that it's a reservation. It's a reservation to get the people out of the backwardness of the region. It's a regional reservation. They are not entitled for that class at all. But domicile is applicable, in my view, only for the citizens of India. No, that there's no clarity on that as such. But they have to have undergone the problems of that region to get the benefit of the region. That is the whole crux of Article 371J. It is given to those people to benefit who have undergone the sufferings. 7B. 7B. Not in 7B, my lord, it says an overseas citizen of India, 7B2. Please. Please. The strength of my argument only lies on 371J. Good. So that's the only reason why I gave the bill of that 371J.
As far as I'm concerned, well, for the government is the authority to decide as far as. But my submissions to your lordships is not 371J, by the very fact, my lord, that the wordings are provided in the 370 is the reservation. So, my lord, it is termed as special provisions. When you give, my lord, apply this special provision to a class of persons, then, my lord, it amounts to reservation. All reservations, my lord, are coupled with the sufferance. Are coupled with sufferance. Because of the sufferance of the person, well, having born or brought up there, then they are entitled for reservation. Here is a case, my lord. No doubt, my lord, the parents were one of the parent. He studied here. He comes under clause 3, my lord, in the notification. Notification, clause 4, 3. Clause 4, no, subclause. He banks upon, my lord, the domicile as a local person. Domicile as a local person. The student now, he claims, petitioner, claims a domiciliary nature of the parent. Having studied for 10 years, more than 10 years. At the cost of repetition, I may read clause 4 again. A candidate, that is what page, clause 4, page 519, my learned phrase given. A candidate for admission to any course of study shall be regarded as a local person in relation to the local area. Local area has been defined in clause 3. If he is born in the local area, either of his parents was born in that region before 1/1/2013, or either of his parents ordinarily lived in the local area for more than 10 years prior to 1/1/2013, and had their name either in the electoral list or ration card, or owned an immovable property on or before 1/1/2013 in the local area. He don't qualify here. Then, my lord, the clause B. In case where a minimum educational qualification has been prescribed for admission, here he may fall, my lord, in any one of the. Here there is a minimum education qualifications provided, says pre-university, and also, my lord, the qualification under the NEET. Then, my lord, where he comes. If he has studied in an educational institution or educational institutions in such a local area for a period not less than 10 years. I'm sorry.
Yes, that you need not wait. Please. You are welcome to sit, but if you are sitting for that, we continue this.
Yes. in clause 1, if he has studied in an educational institution in such local area for a period not less than 10 consecutive academic terms. Here he doesn't qualify, student doesn't qualify. He's studied only 7 years or so. Then next, where during the whole or any part of the 10 consecutive academic years, ending with the academic year in which he appeared, or as the case may be, first appeared for the relevant qualifying examination, he has not studied in any educational institution, if he has resided in the local area for a period of not less than 10 years, immediately preceding the date of commencement of the qualifying examination in which he appeared, as the case may be. Again, here he doesn't qualify here. 10 years is not only 7 years. Now, clause 3. He is trying to come in this mode, where either of his parents has studied in an educational institution in such local area for a period of 10 consecutive academic years. Here, it is an admitted fact, not the mother of the father of the student has studied 10 years, not he has produced the documents. He is trying to come in here. Then, where no minimum quality, I am skipping it. Now, now comes to the sufferance part of it. Now, after this, for a moment, we'll forget this clause. The father, even as on now, he is a British citizen. Both the parents are British. British citizens. Because they have acquired the British citizenship by moving into the UK. Then the child, having born there, acquired the citizenship by birth of UK. Yes, sufferance aspect out. That is one thing. Now, what is the right of the OCI cardholder? OCI cardholder's rights are very limited. But with the stroke of a pen, the OCI card could be cancelled. With the stroke of a pen, they will not get anything more than what has been given by virtue of the notification issued under Section 7B. Now I'll take your lordships to the notification itself. This is on 4th March 2021, my lord. In para 21 of the Anushka's judgment. I will read the preamble to the notification because it supersedes our earlier notification. Because petitioner has to fall back on any one of the notifications to claim as an OCI. Lordship got it, it's at page 11 of the reported judgment. Reported. May I read now? I'll read the preamble to the notification. In exercise of the powers conferred by subsection 1 of Section 7B of the Citizenship Act 1955 and in supersession of the notification of the Government of India, the Ministry of Home Affairs published in the official gazette number so and so dated 11 April 2005, and the notification of the Government of India in the erstwhile Ministry of the Overseas Indian Affairs published by the gazette dated 5th January 2007 and 5th January 2009. There are 3 earlier notifications were superseded by this notification. Except as respect things done or omitted to be done before such supersession, the central government hereby specifies the following rights to which an overseas citizen of India cardholder, hereafter referred to as the OCA cardholder, shall be entitled with effect from the date of publication of this notification in the official gazette, namely, one is granting of multiple entry. Two is, my lord, exemption from the registration with the foreign regional registration officer or foreigners registration officer for any length of stay in India. Then, my lord, parity with Indian national in the matter of tariffs in airfares in domestic sectors in India, and entry fee to be charged for visiting national parks, wildlife sanctuaries, national monuments, historical sites, and museum in India. This now, my lord, again I pause because one of the prayers which is made, my lord, the fee reduce the fee for the application form. They want, my lord, a reduced fee for the application because for NRIs and, my lord, the OCAs, the application fee is higher than the Indian nationals. So that also they want the refund now. Yes, no, with the transmission. That, my lord, the 4. 4 is important. Parity with non-resident Indians in the matter of inter-country adoption, I'll skip that. 2, appearing for all India entrance tests, such as national eligibility entrance test, joint entrance examination, mains, JEE, my lord, or such other tests to make them eligible for admission only against any non-resident Indian seat or any supernumerary seat. Notification, the notification which is at para 21, page 11. My friend has put it, if your lordship sort of see the paper book, ballot, it is there at page 117. Yes. Yes. Then, my lord, there is a proviso to this clause. The proviso says, provided that the OCA cardholder shall not be eligible for admission against any seat reserved exclusively for Indian citizens. Of course, this is which has been called in question in Anushka's. And there is a, got it, no? Proviso to clause 4. The clause 2 of clause 4. Provided that the OCA cardholder shall not be eligible for admission against any seat reserved exclusively for Indian citizens. Now, my lord, for the purpose of this, who is a OCA? That is also explained by the notification itself. Your lordship, there is an explanation clause, my lord, down below in the same page in the explanation for the purpose of this notification. That is at page 12 only, when down. That's got it, man. For the purpose of this notification, the OCA cardholder, including a PIO cardholder, is a foreign national holding foreign passport in a foreign country and is not a citizen of India. So therefore, what I say, he has been given to treat him on par with my lord, the citizen of India and not as a citizen of India. I make this small distinction. He could be treated on par with citizens of India for the purpose of this admission, but not as a citizen of India. Here, not SC, ST, all reservations is meant for citizens of India. Therefore, my respectful submission is, my lord, he can't be treated as a citizen of India. And according to me, my lord, the 371J benefit is a reservation. And for the purpose of applying that reservation, he is not a citizen of India. He is not only a foreigner. Now I'll come to my lord, the Anushka's case. My lord, in very vocal terms, the judgment says, my lord, the student who has pursued her education as having the same advantages, disadvantages, like that of any student who is an Indian citizen. That is what they have specified. Now, my lord, while concluding it, para 55, my lord, the reasoning starts. Para 55 is that, my lord, the conclusion part of it, my lord, I'll read that. And what is the benefit given to them? Therefore, in the factual background of the issue involved, to sum up, it will have to be held that though the improved notification letter 43/2021 is based on a policy and in exercise of the statutory power of a sovereign state, the provision as contained therein shall apply prospectively only to the persons who are born in a foreign country subsequent to 4/3/2021. That's the date on which the notification and who seek a registration as OCA cardholder from that date, since at that juncture, the parents would have a choice of either seek for citizenship by descent or to continue as a foreigner in the background of the subsisting policy of the sovereign state. Here I pause for a moment, my lord. In the instant case, neither the parents have wanted to renounce their Indian citizenship. They still continue to be foreigners. Then, in the light of the above, it is held that the respondent one, in furtherance of the policy of the sovereign state, has power to pass appropriate notifications as contemplated under section 7B1 of the 55. Actually, the notification, I say here, the Honorable Supreme Court very rightly, my lord, very thoughtfully not quashed the notification. Therefore, as far as petitioner is concerned, he falls under only this notification. He can't go behind the other notifications at all. Now, my lord, when these matters are being heard, there are many matters before the Honorable Supreme Court, and many interim orders were passed. In some of the interim orders, my lord, the court has specifically said they are not entitled for reservation. I have produced one of this thing along with my statement of objection. I'll come to that. In paragraph 58, While, my lord, regularizing all those interim orders, the court says like this. We further hold that the petitioners in all these cases are all similarly placed OCI cardholders will be entitled to the rights and privileges which had been conferred on them earlier to the notification dated 4/3/2021 and could be availed by them, notwithstanding the exclusion carved out in the notification dated 4/3/21. So what we have given earlier, no reservation to given to them at any point of time. They were never given any reservation in the earlier two notifications also. Then the participation of the petitioners are similarly placed OCI cardholders in the selection process and subsequent action based on the interim order, based on the interim orders passed herein or elsewhere shall stand regularized. Now I'll come to the interim order. Your Lordship may kindly take, my lord. In the petition itself, Your Lordship may kindly take page 85 of the petition. It starts from the interim orders. Yes. Page 85, Your Lordship got it now. While passing an interim order, the petitioners are permitted to appear for the counseling in the general category. Page 85 of the paper book. This sort of an interim orders were passed since 2020, 21, 22, my lord, counselings. This is pertaining to 21, 22. Then, my lord, the next one. There also, my lord, at page 86, they are permitted to appear in the counseling in the general category, down, my lord, at par with Indian citizens to pursue their respective courses. This is 21, 22 again. Then, my lord, 8/11/2021, 88. There again, my lord, at page 89, four, 5 lines, my lord, down. In general category on par with Indian citizens. And now, my lord, your lordship may kindly take for a moment, my lord, my statement of objections which I have filed. It was filed on my 5th July 2024. Then I have produced annexure R1, my lord. This is again an interim order passed by the division bench of this honorable court. My lord, where there is specific, no doubt, my lord, when my learned friend made a submission, I am not claiming reservation. Nevertheless, my lord, in fact, my lord, I argued this matter, I was there. We apprehended, my lord, others similarly placed students may claim reservation. Therefore, my lord, the last, my lord, not ready for it. The internal page 3 of the is in the writ petition, right? My objection, I'm sorry, my objection statement. Annexure R1, there they clearly say, my lord, his merit will merit in both Yes, no, it's in the, my statement of objection, Your Lordship got it, no, on filed on word of 5-1, 5-7. 5. That's a statement of objection filed by the second respondent. Yes. This is one of the interim orders which has been passed, Annexure R1. It starts from page 7, page 9. My lord, I'll skip all that, my lord. Page 11 there. Page 11, penultimate paramal. Pending disposal of this writ petition, we permit the petitioner who has appeared in it 2020 to be counseled by the respondent 3 and 4 in accordance with this merit in both state quota as well as in this institutional quota without claiming any reservation. Why I am troubling your lordship to see all this is, my lord, all such, my lord, interim orders passed either by the apex court or the Zonal court, wherever the matters are pending, but they get regularized by this judgment. The court specifically said whatever benefit was given earlier by the courts is continuous. And my lord, in the entire judgment of Anushka, question of reservation, my lord, was never discussed. It was never, my lord, the subject matter of the petition or all the proceedings. Therefore, my lord, if they want to make any inroads, my lord, from this judgment, either they have to go to the Supreme Court and get it done, because it is only, my lord, that their rights are crystallized only by the notification. Notification doesn't give reservation. Judgment doesn't give reservation. Now they want to make an inroad, my lord, and claim reservation detriment to the interests of other state students. In general category, my lord, we are giving. We made a submission in the earlier petition, your lordships have disposed of. We are thoroughly, my lord, fallen in line with the, my lord, the judgment of the Honorable Supreme. Therefore, my respectful submission, my lord, they are not entered for any reservation as such, my lord. Obliged. One last submission. Well, my friend has made a, my lord, submission there before yesterday that PWD quota, persons with has been given. Your lordship kindly take, my lord, the act, Rights of Persons with Disabilities Act 2016. But this act was promulgated by virtue of, my lord, a convention which has been adopted, yes, 16 Act, my lord, that the United Nations conventions, which has been adopted, it is irrespective of, my lord, the reservation. This is not a reservation as such. Any person with a disability is entitled for, my lord, wherever he is. Therefore, therefore central government is given. This can't be, my lord, used as a tool, my lord, to claim a reservation in a state.
ASG will be coming for this case tomorrow, Milo. Yeah. Tomorrow. Today is not available. Today is not available. He is in Dharwad actually.
Would it take 2:30 minutes?
Tomorrow at 2:30. Item 63, my lords, I made a mention in the emergency, my lords, in the matter. But around the farmers are hesitating, I have to pay a salary of 700 people. Lord, I am not able to crush the sugar cane. It's only a mandamus covered by judgment of my lord's coordinate bench. But sometime, my lords, tomorrow or day after 2:30, it will not take more than 5 minutes. 63, my lord. But some time, my lord. It is covered by judgment, mandamus, my lord. I will not take more than 5 to 6 minutes for. I have already placed the judgment on record. 8. Lords, 2:30, my lords. Lordship may kindly accommodate.
Thursday.
Will not take more than 5 minutes of your lordships.
Kindly, my lord.
Great.
Lords.
Oh, pleadings are. Pleadings are. Pleading synopsis also.
Kindly, my lord.
8 to 2:30, my lords.
38th matter, my lord, they have taken time, my lord, to comply with the order on 27th, on any date next week. 38th. Next week, my lord, 2:30, my lord, they have more than.
My lord,
They
may
have
I
taken
request for
time,
some
my
more
lord.
time in that
11 years
matter.
old matter, my lord, they have taken. 38th. 38th. Serial number 57, my lord.
Serial number 57, my lord. Others can inform me that the are required 4 weeks time to comply the orders. Will call the matter after 4 weeks. My learned friend informed me that respondents Tahsildar requests 4 weeks to conduct the durasti. All the matter after 4 weeks.
May I please your lordships, like, serial number 49, my lord. My lord, it will not take not more than 5 minutes, my lord. Only complaints, that's all. 25.
Serial number 57, my lord. Serial number 57. Maybe called during first, next Monday or Tuesday, my lord.
Serial number 47, my lord, I appear for the petitioner. Serial number 78. For withdrawals, serial number 78. Akshit Kumar.
Even Ramesh are your parents,
Bus 79. Varun MR. Serial number 47, my lord, I appear for the appellant in this matter. This matter was heard and the learned AGA was directed to seek instructions regarding the genuineness of the grant made in 1962 in favor of the appellant, my lord. A date, short date may kindly be fixed, my lord. 47, serial number 47. A short date may kindly be fixed, my lord. In this month only a date can be. It pertains to the grant of land in favor of the appellant, my lord. The contention of the respondent is that my grant is not genuine. And the last date of hearing Interim order may kindly be extended.
One submission.
Number 75.